That one. There you go. That one. Can you guys hear us on Zoom?
I can hear you.
Thank you. We're gonna do a quick roll call. So if everyone on
I can
Zoom-
hear you.
Thank you. We'll just do a quick roll call. So we have Debbie Hockaday, Chris Gonzalez, Lee Jackson. I'm not sure who, I see Lisa Tibbles, but the other Lisa, could you give me your last name, please? Okay, so we have Lee Jackson, Thomas Brenner, and iPad. Do you want to change your name? So we have you here and accounted for, and Pam Martinez. In the upper right, you can rename yourself if you like. Okay, so we're gonna go ahead and get started. Thank you, everyone, for coming out on a Saturday. We all know how much we all love to leave our homes early in the morning. So to get started off, District Attorney Steve Rye is going to do the open meeting law. He's going to go over his presentation with you. We're going to try to keep the questions down to a minimum so we can hopefully get through his presentation as quickly as possible. And then also it records really well on the end if someone else has to watch it later. So if we can do Q&A after he's done with his presentation. We handed out some of those packets with his presentation, the lines for the notes. So if you have a question, please designate your question on your paper, and then he will go through after he's done and review any questions you guys have. So following him, I will go through the CAB handbook training. We will go over agendas, minutes, board processes, letter transmittals, the whole spectrum of what your job tasks and duties are. And then following that, Andrew Haskin will be going over planning. I'm not quite sure what your title is for that one, but he's gonna be going over planning, zoning and stuff. I haven't quite looked through all that, but so. I'm sorry. Oh. Oh. Yeah, so everyone online, if I did not go over your roll call, can you please send me an email and letting me know that you're here for today so that we can make sure that everyone's accounted for who's on Zoom, please. So I'm going to turn it over to the district attorney.
There was a question, I think.
There's a whole bunch of paper up here. You're free to come and grab one of each.
All right, good morning, everybody. Thanks for coming this morning. I'm going to do the open meeting part of the presentation, and then like Erin said, she has a presentation on the cabs and some of the things her office does, and then Andrew will finish up with questions and then the presentation on the planning. So I have a presentation that's similar to what I've done. If you've been to one of these trainings before, we try to do one every year. And so this is similar, a few updates with changes in the law and things, but I'll go through it fairly quickly. I know it's easier if we ask questions along the way, but because Erin's doing the Zoom and trying to record, we're going to do the questions at the end. So try to write down your questions and then we'll have a Q&A at the end. So that gets started. So the training objectives today, try to give you just a general understanding of the open meeting law, some of the common issues we see that come up during the CAB meetings and planning commission, county commission, the meetings that we deal with on a regular basis, and then some of the resources that are available to you if you want to learn more about the open meeting law. The legislature has included in the law the declaration of intent, and this is just the overriding principle that we all want to remember when we're considering the open meeting law. All public bodies exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. If you remember that, the open meeting law is fairly straightforward. Key points Actions open, deliberations open. This is a quote from the Supreme Court a few years back. The open meeting law is going to be construed liberally and broadly to promote openness. So they're going to always err on the side of the public when they consider open meeting law violations and complaints. The court also said in that same case, though, that the open meeting law does not prohibit every private discussion among board members and the public, staff reports, other things. Those things are all legitimate if done properly, and it's part of just doing business. The key is that a quorum cannot be involved in any of those discussions, and we'll talk more about that and some of the problems that people can run into. Quick checklist of the open meeting law that we go through when we're determining whether or not it's an issue. Is the body subject to the open meeting law? Is it a meeting? Has it been properly noticed? Is there an agenda? Was there deliberation? Public comment allowed? And any action taken? Does the open meeting law apply? So first, is it a public body that it applies to? And for the cabs, they are subject to the open meeting law. We'll get into a little bit more why in the next couple of slides, but generally a public body is an administrative, legislative, advisory, or executive body of the state or local government. And every one of those entities is going to be subject to the open meeting law. Here's what the statute says with respect to the those bodies that are subject to it. Anything created by the Constitution, a statute, and the other big thing is an ordinance or resolution of a local government. And so some of the boards we deal with, like the Planning Commission, created by statute, County Commission, created by statute and Constitution, cabs created by a county ordinance, also authorized by a state statute. So those are all easy ones to see that they're subject to the open meeting law. Committees, that's an issue that comes up quite frequently with all boards, and they've become a little more strict on that with the open meeting law. Committees are subject to the open meeting law. And so a lot of times the board will say, well, we'll just designate 2 of our 5 members to form a committee, go out, research this issue, and come back and tell us what to do. We can avoid the open meeting law. Not accurate, actually. They've tried to tighten that up so that if you are designating committees to do your board's work, they're most likely going to be subject to the open meeting law. Depends on a number of factors, but just something to be aware of. This is the change they made in 2019. It includes a subcommittee or working group of at least 2 persons appointed by a public body. If they're members of the board or staff members, and if they're authorized to make recommendations. Okay, so that's going to be most of your committees. So just be cautious about that. If you want to create a committee, they're often very helpful and useful. We caution you with the cabs because there's some rules you need to follow. But if you do that, remember that the open meeting law is probably going to come into play. The general rule, again, is if they're appointed to make recommendations to the board, they're going to be subject to the open meeting law. What is a meeting, a quorum, and why is this important? The meeting is defined as a gathering of the quorum of the members of the board to deliberate towards a decision that's related to that board's activity. Nevada's a quorum state. There has to be a quorum present for the open meeting law to apply. A quorum is a simple majority of the members of the public body, or unless there's another proportion established by law. In all of our cases, it's a simple majority of the members. Elected boards do have different decision rules. They require a majority of the elected officials to support a decision. Cabs, you just require a quorum. So if you have 5 members, 3 is a quorum, 2 can approve an item. Not true with an elected board. County Commission, they need always 3 votes in the affirmative to confirm a decision. Meeting and audio visual requirements. Just some of the general provisions. You have to make reasonable efforts to ensure that the place that you're having the meeting are large enough to accommodate the anticipated attendance. Rarely is this an issue, but every once in a while, the CABs or the county commission or the planning commission will have an item that is pretty, garners a lot of public interest, gets a lot of people out. You just need to be aware of that. If you're going to pack the house and you're having your meeting in a small location, maybe you need to think about moving it. Not very often, just something to be aware of. Teleconferencing and video conferencing, the thing that's really popular now, like we're doing today, you just have to make sure that the people that are on and either video or teleconferencing and that they can hear what is going on and they're allowed to participate. We'll talk more about that as we go. Whoops, what'd I do? We'll talk more about that a little bit as we go along further. Serial meetings, does that constitute a meeting? So I said that you have to have a quorum of members in order to have a meeting. And so what happens is sometimes board members will talk to one another and share information. So what's the end result? Pretty soon, every board member knows what every other board member's doing, no meeting, and you have a violation of the open meeting law. So what the serial briefings are something we're very concerned about when we're looking at what the boards are doing outside of meetings. And this is a Supreme Court case that decided sort of the serial or walking quorum issue. And we'll go through a little bit what that means. So it's a situation where you have less than a quorum present at any one gathering. So you might have two board members meet together, discuss an item, not a violation of the open meeting law, right? And then the next one of those members meets with another board member, discusses the same item, shares what they talked about with the other board member. Pretty soon you're starting to form a meeting. You're getting a majority of the board discussing the same item, knowing what everybody's thinking, even though a majority of the board members haven't gotten together. So that's kind of what we're talking about with a serial communication. The other area where it can be a problem nowadays, we all do things by telephone, text, email, all that kind of stuff, right? So we're just going to send out an email. Pretty soon that email sent out. Every board member's on that chain of emails discussing an item that's coming up on the agenda. What's the result? The result's going to be that you are violating the open meeting law if you're having meaningful discussions that are going to lead to the decision. So we're always cautious about emails when you're a board member. I think Erin will talk a little bit about this, how the CABs have emails set up and some of the instructions and guidance she gives so that we try to avoid a situation where all the board members are communicating by like text or email or something like that. We just want to make sure the decisions that you're making are done in the meetings so that you don't get in trouble for violating the open meeting law. This case is kind of one of the big Nevada Supreme Court cases on the serial communication, the walking quorum. And it's sort of an antiquated example, but it just give you an idea. And this involved the Board of Regents, the University Board of Regents. And one of the regents made some comments to the press criticizing certain decisions of the board. And we've seen that with boards and probably happens on the boards that you each sit on, that sometimes there's disagreement among the members. And so some of the other members said, we don't like those comments. And so I'm going to call the chair and tell them that those comments were inappropriate. And so the chair met with the public information officer, asked that she draft a response to those comments. They prepared a response, cover letter, sent it to all the regents, but the person that made the comments. Okay, it said it would not be published until approved by the board. Letter requested feedback, asked whether they should move forward with this course of action. Board members responded. Nothing was ever issued. No press release, no correspondence, nothing to Nancy Price, the one regent that made the comments. Complaint filed. What do you think? Violation? Yep, that's what the Supreme Court decided. And so, yeah, so in this case, it was fax and other communications like that, telephone. But the Supreme Court said you can't do that. So it's just something that's it's become easier with our electronic communications. It's so much easier now to communicate than it used to be. And so it's just something we always need to be cognizant of as board members. Some of the exceptions to the open meeting law, if you're in a legal briefing regarding pending, potential, or existing litigation, it is not a meeting. Communications with the board's attorney generally will not be deemed a meeting. One of the things on emails that Erin will probably touch on too, that we always encourage is if you get emails regarding the board, regarding a meeting, something like that, we always encourage you not to reply to all, because a lot of times you'll get an email and you'll say, oh, that's great, hit reply all, because that's the way the email works. And you don't realize there's 20 people on there, including every one of the board members. And so you can just create issues for yourself, especially if you get like emails from the public asking about an agenda item that's coming up or something like that. So we just want to caution you to, if you do respond to emails, be careful about hitting reply all, because it can create an open meeting law problem. Whoops, I hit another wrong button.
Split share screen again.
Oh. Methods of holding a meeting. Obviously, we can still have meetings in a location. There's some legislation, I think, that's before the legislature this year to require that there be a location and that certain board members attend at the location depending on the circumstances. But also now we're allowed to do meetings by telephone, video conference, and the most common is remote technology system, which is like the Zoom meeting we're doing today. This was in response to COVID-19 when they shut down everything. They had to figure out a way for local governments and boards to conduct business. And the easiest way to do that was the Zoom and other options. So the governor issued one of his many directives was to allow this exception to the open meeting law. And these changes were made permanent in 2021 with some AB 253. And so this authorizes a public body to conduct a meeting using remote technology system, requires that notice only be posted at the principal place of business and online county website and the state website. And if it's an elected board, there must be a physical location for the meeting. For advisory boards, it is not required that there be a physical location, but the county still requires that. The law does not, but the county will. Some of the important things to notice, like I think there's one CAB that does Zoom meetings now, and the county's addressing some of those issues, but you need to make sure that the facility is set up to do it properly. And those are things you have to work with Erin and Andrew on before you can do the remote meetings. Some of you remember the old days, you had to post the agenda at 3 locations. Kind of a pain to get that done and coordinate where it was, especially if your Central Line Park Board, you want to post it from Mound House to Silver Springs, get it out and about on the agendas. That was pretty cumbersome. With these changes, you no longer have to post that agenda. And it's just a sign of the times again that people pay more attention to the internet than maybe going to some county building to see what meetings are coming up. Doesn't mean you can't post them, but you're not required to legally. You have to, if you do have a remote meeting, you have to provide for live public comments during the meeting. And the same notice and posting requirements for the agenda as if you were just having a meeting at a physical location still apply. Some more requirements for these remote meetings. Just the key is you have to be able to hear and observe each member, and each member can participate. Also, the public must be able to participate. Some of the other concerns we have now with the remote meetings and everything else, even the in-person meetings, where we see problems potentially with violations of the open meeting law and deliberation towards decision, is some of the social media things, right? Again, social media is a great way to communicate. Facebook, Twitter, all these other, Snapchat, all these things. Again, they can go out to large groups. Responses and everything else will be shared with everybody. So we do urge you to be cautious about social media communications if you're a board member. If it's something that's under consideration, remember that could be used for not only prejudging, which isn't an open meeting law issue, but it could be used for communication leading to deliberation and a decision. The other thing we talk about some, and again, this gets a little bit more difficult too with remote meetings. If you're at home, you're on your computer already, and you want to look something up, you can just do an internet search. You can find what you want on the computer. You're doing your own research while the board presentation is going on, basing your decision on materials and backup that may not be available to anybody else. That can be okay under certain circumstances, but you need to be careful about that too, especially on your planning items. The applicants for planning items need to know what it is you're considering to reach their decision, right? They have a private property interest. They need to know what you're basing your decision on. So we encourage you to rely on the information that's provided by staff. If you are using outside information, we ask that you share that with staff and the other board members, that we just want to be open in terms of the open meeting law and what information is backup and what you are using to consider your decision. Exemptions to the open meeting law, social gatherings, you're allowed to go to things like this, others trainings, social gatherings, events in the community, school events, all those kinds of things that board members want to attend. You're certainly allowed to. You're allowed to talk to your colleagues, do all that kind of stuff. It's not going to be a violation of the open meeting law. Just remember, you don't want to make your decisions regarding your board activities at those gatherings. Posting the agenda requirements. The cabs will generally work through Erin, making sure that they're meeting the compliance. Usually the requirements are at the principal location of the entity, probably the county manager's office. Sometimes it's the location of the meeting. On the internet, county has a website. All of your agendas are posted on that website. They're also posted on the state website. 3 full working days before a meeting. Working days exclude weekends and holidays. And the agenda needs to be presented to the people that have requested it in a timely manner, which means that same deadline needs to be met. All right, so if the agenda has to be posted 3 days before, if somebody's requested that agenda, they get it 3 days before too. Public notice documents. A few years back, they changed the law to require that the person that's doing the posting of the agenda needs to have maintained documents that show who did it and what was done. And so if you have agendas posted at a location or something like that, there's a form you can fill out just saying on this date and time it was posted at that location. Probably never comes up really, as long as the agenda is done. But if there's a question, hey, I don't think you posted it in time, we want to have that information readily available to say, yes, it was posted, or no, it wasn't. And in that event, we would postpone or cancel the meeting. Agenda language. This is an important issue, comes up frequently, and there's a number of reasons why. And this is the main rule that we all deal with on agendas, and that's the clear and complete rule. The agenda topics must be specific to alert the public to the topics that will be discussed by the board. Make sure you draft your agenda so that it spells out what the board wants to do. And I know that sounds very simple, but as board members, we all know that sometimes you get in a meeting, you read that agenda item and you think, we can't do what we want to do. And so you lose a month or whatever till your next meeting when you have to re-agendize it. So think in terms of here's what the board is before the board, and we either want to approve or deny this action. And then look at your agenda. Can we do that under the agenda? Hopefully the answer is yes. What we are trying to do more at the county, which seems to be working fairly well, is we want to have the agenda language as near as possible match or allow the action that the board is taking. And I'll go through a few examples. And then you also, if there's questions on what might happen, as long as it's the same topic, we encourage you to include more in the agenda, not less. Remember, the board can always take action that is less than what is on the agenda, but you cannot take more. So if you want to, you may want to consider more than one thing under the same item. Make sure your agenda is broad, not narrow, so you can do those things. Here's just a few examples from recent agenda items. No reason that these were particularly picked, although they do show kind of what we want to see in an agenda item. And I'll talk a little bit more about this. This is a planning item that probably went through the, I don't think it went through a cab, but the planning commission recently, and it just was on the agenda last week before the county commission. It was for a solar facility in Wabasca. And so you can see it's pretty detailed. It's got the 4 possible action and then the item spelled out in pretty good detail. Here's an example of one that was on a couple meetings ago on the Board of County Commission again, just to approve an interlocal agreement between Lyon County and the Lyon County School District for the Smith Valley Library. Here's one from, I think, the Silver Springs cab. I'm not sure when it was, maybe a month or a couple months ago. Again, very similar what the county would use, except it's a recommendation rather than an approval. But shows you here, they get language that's very close to what staff would provide in terms of the application and the other information, okay? And so if you have an agenda item written like this, you can see how easy it is for a board member to make a motion. Because your motion can just basically be reading the agenda. Move to recommend denial, a recommendation of denial for a request from DG Locust Grove Circle K LLC, finish off the rest. And you have just made a motion that matches, that gets to the decision you want to make and matches the agenda. And there's no question, did the agenda relate to the decision? That's kind of what we're shooting for. It doesn't always work that way, but these just give you examples of how, if your agenda's carefully thought through about what the item is before the board, it ties in nicely if you as a board member want to make a motion to approve or deny or modify that request. Clear and complete. This is an example. This is the issue that comes up a lot. Most often, I think, in the cabs, if there is a violation question, and it is the agenda clear and complete. And it happens to the county commission too. We'll talk about an example of that here also. This is, I think, an Incline Village GID agenda example that I've used for a number of years. But the agenda stated District Board Policy 3.01, conduct meetings of the Board of Trustees, specific section 011, officers of the board. On that agenda item, the board voted for and approved a reorganization of officers. What do you think the result is? Yeah, I mean, I read that agenda item and I can't tell what they might even be thinking about. It's hard to tell, right? And so, yeah, and they went ahead and did that, and sure enough, the AG said that's not clear and complete. The public has to be able to tell what's going to happen. And this is another issue that comes up from time to time. They have to be able to tell from the agenda. The board may say, well, we have the backup right here and it says everything we're going to do. It has the detail of what we want to do. That doesn't count. It has to be on the agenda. The backup's very helpful. We want to have good backup, but that won't get you around the agenda requirement. This is the Lyon County open meeting law violation. You may have heard about it I think it was January that the Attorney General issued its decision. And this just shows you what the agenda item actually was on that. It was back in 21 and the board was considering legislative issues, basically bills that were coming before the legislature. And as everybody knows, the legislature, especially as the session gets going, moves pretty quickly. Like you don't have 3 days notice before a bill is going to be considered. So as a board, if the CAB wants to consider legislation, whatever, make recommendations to the board, you need to be careful about doing things if it's not clearly stated on the agenda. So this is a broad agenda item, said that we will consider legislative items that come under that are relevant to the county commission, and the county commission is going to make recommendations to the legislature. What do you think? Huh? Yeah, so that was, yeah, basically what the AG said is you can't provide sort of an open-ended. The public has to know, because right, there's 1,100 bill drafts or whatever crazy number it is. You can't say we're going to consider legislation. You figure out which 1,100 you have to review. And so that's kind of the bottom line on it. And so you just need to specify with a little bit more information what you're going to consider. And so the county has changed that this year, and we're working through those changes, but it seems to be working well so far. Yeah.
So if somebody thinks that we've done something wrong.
If there's a violation that somebody assumes we did as a just a public figure, you know, people coming in, they automatically go to the Attorney General. It seems like
Yeah.
this is for big name, you know.
Yeah. So did everybody hear that question? The question is, if somebody alleges a violation, does it automatically go to the Attorney General? The answer to that is generally yes. The Attorney General by statute has authority to enforce the open meeting law. So most all complaints will be filed with the Attorney General's office, and then they do a review. You can also take legal action under the open meeting law and file a lawsuit against the board or the entity that made the alleged to have violated the open meeting law. But that the general rule is the Attorney General will review all the complaints. The other items that the agenda has to include: time, place, location of the meeting, where the notice has been posted, clearly indicate the action items. We now generally require that any item you're going to take action on has the words "for possible action." Has special notice for those with disabilities, and must allow 2 public comment periods. And then who you contact to get the agenda materials. This is just a little more information on the agenda notice requirements. We usually include on the agenda, and I think most of the CABs do this too. I don't think it's required, but a good idea to include that you can take items out of order. You can combine or remove items at any time. Your public comment restrictions, limitations, and periods of comment must be included on the agenda. Some of the problem areas for the CABs and how do you deal with them: workshops, reports, presentations, updates, future agenda items. Remember, a lot of times we think, well, we're doing a workshop, so we're not going to put possible action. We just encourage you to think about that, because sometimes you do want to take action. As long as the agenda is clear, you can do that. Examples might be like, we're going to have a workshop on code enforcement solutions for Stagecoach, or whatever it might be, right? It's pretty generic, but you may want to, at the end of that meeting, you have compiled, the board that says we have compiled 3 things that we would think would be great for code enforcement, you know, whatever, the county budget, $100,000 for stagecoach code enforcement, that the county hire another code enforcement officer, that the county make recommendations to Andrew, whatever it is. At the end of that workshop, you might want to say, the board is going to pass that recommendation on to the county commission. If you just have it as a workshop, though, you're not able to do that. You would have to bring it back on the agenda of votes for possible action. So sometimes a workshop is intended to gather information so you can actually make a recommendation during that session. In that instance, we encourage you to go for possible action. Reports, again, those are pretty tough. Usually they are not for possible action. A lot of times that's elected officials. Others come before you just with the report. If you want to take action on what they say or something like that, you usually have to put it on a separate agenda with clear information on what you're going to be doing. Presentations, again, similar to workshops, sometimes you may want to take action, not necessarily to approve the presentation or something like that, but you may want to do something. So it's turn off automatically after, but you just gotta hold it. There you go. Okay, thanks. Yeah, sometimes you want to, again, make a recommendation or something based on a presentation. If that's the case, just make sure you note it as for possible action. Make sure your agenda is specific on what you're going to be doing if you are planning to take action. So just something to think about. You don't have to make it for action, but I know sometimes the board, the county commission, planning commission, or the cabs are frustrated because they do a workshop or something and they don't want to take like major action, but they want to say as a board, let's recommend this to the county manager or whatever. That's action. And you can't really do that unless it's agendized for action. Just basic public meeting rules, stick to the agenda. Sounds easy. In practice, it's not always easy, right? Because you talk about a topic and pretty soon everybody's fired up and you're talking about something that's way broader than the agenda. You need to be careful about that. That's kind of on the chair. If the chair is not doing it, the other board members need to step in and try to channel it back to where it goes. We always encourage that all the comments and presentations are made through the chair. A lot of people ask me, well, they weren't following Robert's Rules of Order. Robert's Rules of Order are good ways to conduct meetings, but they're not a requirement of the open meeting law. We do not require board members to follow Robert's Rules of Order. We do use them for guidance, but it's not the same as the open meeting law. But we do take some of the things that work well there and encourage boards to do it. One of the most important is if you can work things through the chair. What we like to avoid is like members of the public arguing with each other, talking to one another. Makes it hard on the people on your board that are trying to take minutes. Makes it hard on Erin trying to review those minutes, review the tapes, whatever, if an issue comes up. So it just helps with the order and the conduct of business. Tends to make the meeting sometimes a little more professional also. Public participation, key part. The way we pretty much every board does it in Lyon County, and the way we encourage you to do it is 2 public comment periods, beginning of the agenda, end of the agenda. We also encourage public comment on each agenda item. It takes some additional time, but we've decided that's the best way to do it. That is not required under the open meeting law. It's an either or, but we generally encourage you to do the public comment before the meeting, end of the meeting, and on each agenda item. Let's see. If somebody requests that their comments or prepared remarks be included in the minutes, public participation, you must include them in the minutes. Public comments may be received by email, voicemail, whatever else. Remember that though, if it's not requested, they be included in the minutes, they don't automatically have to. And sometimes the minute taker, has to decide what goes in and out. A lot of times you'll have hearings that are quite lengthy. You can't copy verbatim. We understand that. So you figure out what's going in and out of those minutes. Generally speaking, Public comment is not a question and answer time. If you want to put items on a future agenda, that's the way to address it. But a lot of times during the meeting, somebody gets up, makes public comment, and you get in a long conversation about an issue, back and forth, questions, answers. Can be a problem because it could be viewed as deliberation toward the decision without it being on the agenda. Request for copies of the agenda. The open meeting law, this is an open meeting law requirement. The person can request a copy of the notice. You can email that. The notice is the agenda. It has to meet the posting deadlines. 3 days before the meeting, your agenda has to be posted. If somebody's requested it, they have to receive it on that same deadline. And it has to be the final agenda. You cannot amend the agenda after the deadline. Okay. That doesn't mean you can't add backup to the agenda. And you'll see sometimes I've had some frustration at the county because sometimes it indicates an amended agenda has been posted. The agenda is not amended because the backup is included. Something has been added. And so we just remember you can't change the wording on the agenda after it's that 3 days. But you can add backup, and we'll talk about that. You are required in some instances to add the backup. Supporting materials. If a person requests that you, those materials, you have to provide those. Again, you provide those at the same time the agenda packet is given and made available. And if there are additional materials added to the agenda after the posting initially, you have to give those to the person that requested it at the same time you give them to the board members. So that if somebody, you send out an email, you get new backup, you send it out to all the board members. If you have people that have requested that backup, they have to get it at that same time. If you give out backup at the day of the meeting, you have to provide that backup within 24 hours. The interesting thing about the backup request, it is not a continuing request, which means you can't make that request for every meeting. The agenda request, you can make a request one time, good for 6 months. Not the same for the backup, but nowadays pretty much we give everything out if somebody requests the agenda, but you don't have to unless they request the backup. Minutes, for those of you that have to take the minutes for your board, just kind of what we'd like to see in the minutes. Certainly the more clarification, the better, so that if something comes up in the future, you can look back and see what happened, see how the board voted, see which members voted which way. The public comments, if the person requests, have to be included. If a board member requests that something be included, that should also be included in the minutes. These are some of the timelines of the minutes. The minutes have to be available within 30 days. That means they are not necessarily approved, right? Your cab is not going to meet and approve the minutes within 30 days, but they're still available. They're just not approved. And the minutes are retained for 5 years, the recording for 3 years. First Amendment public comment issues. This comes up from time to time. You can limit public comment. We encourage you not to. People can say pretty much whatever they want. It doesn't have to be something that's on the agenda. Usually it's not. It doesn't have to be necessarily related directly to the board. We usually just allow those people to make the comments. Again, it's not a question answer session. What we don't want to do though is allow personal attacks, things like that. You don't have to allow those things during the public comment. We don't want to get into any situation where we're limiting public comment though, based on viewpoint. Just a little bit more on public comment. It doesn't have to be relevant, wise, any of those things that as board members, sometimes you're frustrated with people that make public comment, what they have to say or whatever. We just encourage you to allow those comments and move on with your meeting. There are time limits usually by most boards, just for efficiency purposes, 3 or 5 minutes for public comment. Because you want to allow people to speak, you want to give them time to state their piece, that sort of thing. It's the chair's discretion to allow more time. Can't allow less, but sometimes you want, maybe you allow a person who's in the middle of something to speak for a little bit longer. Be careful though, if you do that and the next person comes up and you say no. You want to be really careful about how you adjust that, because again, you're going to be accused of doing it based on viewpoint, right? You can't allow the person you like who supports your position to speak for 10 minutes. The person you don't like who doesn't support your position speak for 3 minutes. It's going to create problems for you. So we encourage you to follow whatever guidelines the board decides. Stick to those. There are times though where somebody has something that the board needs to hear. So the chair will make an exception and allow a little bit extra time, not a violation of the open meeting law. Some of the definitions are talked about. Deliberate. It's basically talking about what the decision is going to be, weighing the pros or alternatives or whatever. Action is voting. No secret voting. The voting has to be done in public. Each board member says what their vote is, and that's recorded in the minutes. Okay, so how to avoid a violation. This is just sort of a general standard. It's not going to be a violation unless you knew that you were doing something in violation of the open meeting law. So, if you know it's iffy, just don't do it. Strict compliance is required, and I don't want to give names or anything, but a number of years ago, one of the boards and cabs in Lyon County was having all sorts of members were in and out, and there was new members, and there was some public input that was contentious, something that a lot of boards do. And so the board did things over a period of time that was consistently in violation of it. And not malicious. It wasn't like they were acting malicious. Okay. Yeah. They weren't acting maliciously, anything else, but they were getting constant violations filed with the Attorney General's office on a monthly basis and every meeting. And the board members would tell me, and they would tell a county manager's office, hey, we're just volunteers. We don't understand the law. We can't be expected to be held to that kind of standard. I understand that we don't expect you to know all the ins and outs and everything, but the AG's response every time is going to be strict compliance. It's not, I tried to follow the open meeting law. That's just not an option. And so I know as volunteer board members, it can be a stressful thing. We want to work with you and support you on that, but you do have to remember that because you're a volunteer board or not paid, whatever, you're not held to a different standard. So it can be challenging. We've had great success. Very seldom do we have any open meeting law violations, but just something to be aware of. This is, again, just follow up on that. The AG they're not out to get you. They're out to enforce the open meeting law. And so that's what they're trying to do. If you're trying to comply in good faith, if you're working with Erin and Andrew and the DA's office and stuff, that's going to go a long ways to show that you're trying to comply with the open meeting law. Corrective action. This is something that is important to know about. Doesn't come up very often, but it can be very valuable if you take action that you find out is in violation of the open meeting law. You can cure that at the next meeting or even in the same meeting. And so it's important that you just have this in mind in case something does happen at one of your meetings, that you can fix the problem. You're allowed to do it within 30 days. This is a case out of Douglas County where they kind of came up with this rule and said it was allowed in the statute and you could do it. And so what happened, a number of issues that we see in this case that come up and you just need to be careful about. But in this case, I think it was a planning item. I don't know if it was the planning commission or county commission. They had the quorum present. They take a break during an item. A quorum of the members are talking about the item during the break. And one of the members comes back into the meeting and says, we were talking about the item, and expressed what they did and said what the conversation was. And in that case, it was decided that because they did that during the meeting, they cured any violation of the open meeting law, right? Makes sense. The public knew what they talked about. The conversation was given so the public could come up and say, hey, that's not right or whatever, but they still had a chance to know what went on. So it's complied with that openness requirement of the open meeting law. There was discussion, they allowed public discussion, all that kind of stuff after. And so they viewed it as they corrected the open meeting law violation. Something that can be helpful, does happen from time to time, that maybe there is some oversight or something, you think, man, that might have been a violation. You can always put it back on the agenda and make your decision. What happens if you violate the open meeting law? The action taken is void. So sometimes that can be a problem for your board. You have to redo everything. You can be sued for it. That's happened to the county. That's happened to other counties, other boards, school districts, everybody else. Lots of boards get sued privately. Can be a crime, misdemeanor, civil or monetary fines, and you can be subject to subpoena, other investigations. Fine of up to $500 if you've actually violated the open meeting law. Nobody gets fined, right? Pretty rare, but this is just one example in recent history. Probably most of you remember Washoe County School District took action to terminate their superintendent. No agenda, no notice, violation was found. They had attorneys and everybody else involved in that decision. Was in the news. Everybody, I think, pretty widely publicized. Nevertheless, each trustee fined $500. The other thing, if you get a violation, the law now requires that you post that on your agenda. So you have to include, if like the Attorney General issues an opinion, you have to include their findings and conclusions of law, their written opinion on the agenda, and the board has to acknowledge the opinion. It's not an admission of the violation or anything else, but it does bring it to the public's attention. Some of the resources that we recommend, the Attorney General Manual, it's on their website, the AG website. It's a great resource, updated, I think, in 2022. And it's been around for years. They do a pretty good job of updating it, has some good examples, agenda, minutes. A lot of the Attorney General opinions and cases are referenced in there. So if you are interested in more information, that's a great resource. Again, I'm always available. Erin's always available to answer questions. We don't always have the answers, but we'll try to look into it for you. Do what we can to help you be able to make the decisions that you want to make and move forward with your board activities. So that's concludes my presentation. Are there any questions?
Make sure if you have a question, you turn on your microphone. I got a question.
All right, Sir Mark.
Okay.
You send the people requests agenda. Who are they requesting that from?
Okay. Are they requesting that information from Erin
Uh,
or from the
what-
actual advisory board?
Yeah, so everybody here, the question is, when people request the agenda, who are they requesting it from? And so the answer to that is probably not one person in particular. As I mentioned, the agenda needs to state on it who you can contact to request that material. So they can be doing it through that person. And so it depends on your board who that might be. All right. The other thing is they may request it, especially with the advisory boards from an advisory board member, something like that. We would encourage that you treat that as a legitimate request and pass it on to the person that's going to add them to the list. So it's not any one person. It's usually going to be an advisory board member or the person listed on your agenda as the contact. That makes sense?
Mhm.
Okay. Any other question? Yeah.
I actually have a,
Oh,
sorry.
Amber, good.
Go ahead.
Yeah.
I kind of have a list. So the first one is board member speaking as a private citizen at a citizens advisory board meeting. I did check. I was told that was okay. Is there anything specific that needs to be done other than stating you're making a comment as a public member or member of the public?
So did everybody hear that question? The question is, can a board member speak as a member of the public at a meeting where they're a board member? And so that's not really an open meeting law question. That triggers some other laws. But as a general matter, yes, you can probably do that. There's some things we would recommend, and I can talk to you afterwards about what that might look like in order to do that. Remember, as a board member, you're a member of the public too. So, but you assume two roles. And so you are speaking on those items as a board member. And so if you want to speak as a member of the public, you should not have any involvement in that item. You should let everybody know I'm not speaking as a board member. Make sure that's very clear. There shouldn't be a lot of situations where you have to do that. Sometimes you have a personal interest in an item. You're going to abstain, recuse yourself, disclose on the record why you're doing that. And then sometimes you might want to speak as a member of the public. That can get into problems though. And you can be accused of using your position to try to influence the board or whatever. So it just can be a sticky issue. It's not prohibited automatically. We just urge extra caution in doing it. I don't know if that answers your question.
It kind of does. It's just, a small community,
Yeah.
yeah. And then can you put you're limited to 3 minutes one time on the agenda? I think there's always confusion in the meetings. People don't understand how open meeting law works. So they don't understand, that they're limited. So can you put it on the agenda? And can you also put, like on the 2 public participation periods, we always get people that want to speak on an agenda item during that first one. And we have to tell them, can you put specifics of how to do public participation on the agenda?
Yeah, we can help you clarify that a little. Did everybody hear that question? Public participation. Can you limit, there's, I think, multiple parts. First part, can you limit somebody to 3 minutes of public participation?
On the agenda, write it on the agenda.
With writing on the agenda. Second part is if somebody gets up, which often happens, they get up at the kind of a general public participation at the beginning of a meeting, and they start giving public participation on an item that's on the agenda. And the board thinks that's better mentioned when we're on that agenda. It's easier for the minutes, it's easier for the board, does all those things. So the question is, can you ask them to do that? So the first part, can you limit them to 3 minutes? Yes, it has to say that on the agenda. Remember though, it's 3 minutes on that item. You can't limit them to 3 minutes, I don't think, on every agenda item. That can be problematic.
Wait, say that again. Sorry.
So generally what you're doing is you're allowing public participation at the beginning, each agenda item, and at the end, right?
Okay. Yeah.
Okay. So you should, if that's the way you're doing it, you can't limit a person to 3 minutes total.
Oh, yeah. Okay.
So
Yeah.
they
No,
get
yeah.
3 minutes, and there are people that maybe do that at some of these boards. They want to speak on every item. They get 3 minutes if your agenda says that on every item.
So it's every item you should ask for public comment, even if it's a presentation, approval of agenda, approval of minutes, every item.
Every item. Yep. Every
Okay.
item you're taking action on, for sure, you need to give public comment.
Okay. And then, like I said, I have a list. I'm sorry. Social media. So I generally send out a link to our agenda and then put on, like if we have presentations or anything other than the general agenda items, I list what's on the agenda in the post. Is that okay?
Yeah.
Okay.
The question was social media. That Stagecoach Advisory Board, right?
Yeah.
Yeah. Send out on Facebook when the agenda's been posted. They post on Facebook, what the items on the agenda. No problem with that. That's a way a lot of people communicate, good way to get the word out. It does not satisfy the posting requirements.
No, yeah,
And it's separate from that. But certainly it's good to let people know in the community when your meetings are and what's being discussed, and that's a good way to do it. So remember though, you can get into social media issues with back and forth and stuff like that. We just discourage that. Andrew.
You're
One
right.
thing. All right.
Just one thing to add to that though, is that you want to make sure that you're not commenting on that. Don't provide any comments as to how you might vote.
Everybody hear that? Okay.
and then the next one, you had said, we know that when they post the agenda on the website, that's the official posting, but we do post on billboards in town and at the community center as well. So will we need to fill out that form, and where is it?
It's on your agenda. So if you put on your agenda at the end where the posting is at, so if you add those other addresses, then yes, then you would be required to fill out that notice yourself.
So if we post it anywhere else besides the,
It's on your agenda.
okay, so we don't have to put it on the
Like
agenda
on
if we just
Facebook,
decide to
spread
post
the
it.
word. You're
Okay,
gonna go here, someone posted it,
okay,
you'll know.
yeah, okay, I was just a little confused on that.
Okay,
Um,
so, and just to, I think everybody heard that question. You have to fill out the form if you post the agenda at other locations, community center, GID, library, wherever it is you post. The answer to that, Erin said, is that if it says on your agenda, you posted it at certain locations, the person that posted it needs to fill out a form that says the date and time it was posted.
Okay, and then my last question is, you had said something about workshops. So, is that separate from a advisory board meeting, or is that a workshop within a meeting, and is there anything different? That slide was a little confusing for me.
Yeah, question is on workshops. Is that a separate meeting or within the meeting? We're talking about workshops within the meeting. Sometimes we see on the agendas that the board wants to have a workshop, which is sort of an open discussion about some topic and, maybe solutions for that topic, recommendations, whatever it is. And you might have a presenter that kind of comes in on something like that, or a number of presenters. And so that's the kind of workshop we're talking about. So it's part of the meeting. And it's the question that I was discussing is whether or not you need to say for possible action on that. Generally, it's not going to be for possible action, but if the board wants to do something like make a recommendation to the county manager at the conclusion of that workshop, it needs to say for possible action.
So I'll give you in case. So a few years back, when we were reestablishing our processes and procedures for our advisory boards, we had our commissioners and we had our planning commission and we had our advisory boards all come together to a workshop. So we had to notice the Board of County Commissioners, the planning commission, and the advisory boards are going to all be in attendance. Because at that point, we could change our processes and procedures. We could, as a group, decide to make changes.
Okay, so
Help understand.
So at our last meeting, we had the Stagecoach Community Center on the agenda as a presentation discussion. There were questions. Would that have been, and the community has a lot of questions about it. Should have that been a presentation discussion or a workshop?
That was probably better served as a presentation discussion, because it's
Okay.
not something that, well, it could have been a workshop, I guess, but in general, that wasn't something that was really part of your board's responsibilities. So as far as facilities management, so a presentation was probably better suited.
Let me ask one following question, sorry, and it's my last one. Okay, yeah, it's in, so as we had a presentation at the last board, and I can't remember if it's you or Doug made the comment that it's coming up before the county for the contract, that the Board of County Commissioners will have to approve the contract. Can we now put it for possible action and go with a recommendation at the next board meeting?
Everybody here, the question was, they had a presentation on the Stagecoach Community Center last meeting. One of the presenters said that it'll go on the county commission agenda for some sort of contract in the future. Can they put on this agenda coming up a recommendation related to that? Yeah, the answer is yes. As long as it's within the purview of the Citizens Advisory Board.
Okay, and then my question relates kind of what she was saying about the workshops in regards to, she had went to a meeting about our drainage in the local area and came back and just made public comment about it. But my question would be is so that we could all discuss it and she could give us more information about it. Like if we had questions while we were sitting there, should we put that on the agenda as a workshop type of item or for a discussion item?
Yes.
Okay,
Everybody hear that? Somebody come in, went to a meeting, got some good information, came back, presented to the board. Board wants to discuss it further. That's an item that should go on a future agenda with the specific nature of the discussion, probably in a workshop, no action setting, but it should go on a future agenda rather than having a lengthy discussion without any agenda item.
Thank you.
See a couple on the, oh, sorry.
Please make sure your microphone's on. If it's not, the red light has to come on.
There you go.
I'm on a 3-person board. So 2 people is a quorum. So what am I not allowed to speak to one of my fellow board members about?
Not much, really, right? It's a tough situation when there two's a quorum. You talk to one about what you're doing, you are meeting. And so you really, if it's an
So
item
what
on your-
can you not discuss?
You can't discuss items that are on the agenda or coming up for discussion and decision by the board.
Okay,
Makes it challenge 3-person board for sure.
it is,
You don't get
yes.
to bounce off items off your fellow board members. Eric.
We can discuss the factual matter of. Can I put this on, for example, Kathy says, so-and-so called me up, and wants to put something on the agenda, and she'll tell me as the chair. That kind of stuff we can do, right?
Right. Did everybody hear that question? 3-member board.
We just can't say, Kathy, I think that's a stupid idea, and we're not gonna talk about it. Then you're.
Yeah.
You've gone over the line.
Feels like
Right.
that's happened.
Yeah, no, that's right. 3-person board. And you need to do the administration of getting the agenda posted and published and what's going to be on there. Absolutely. You have to communicate with board members in order to do that. And so that would be allowed. You just can't discuss the substance of the issue.
I will follow in Amanda's footsteps here. Got a few. First one is teleconferencing and video conferencing allowed but not required.
That's correct.
Okay. And then you were talking about communications and in emails and such. So using, like you said, texts or private emails, those are both subject to discovery, correct?
They are.
And then, I don't know if you know off the top of your head, but I'm interested in the bill that you mentioned earlier that is in the assembly now to require notice of location or something to that effect.
Yeah, I can give you that number. I don't
Okay.
have it off the top of my head, but they'll
Okay.
catch me before the end of the meeting and I'll give you that.
And then on your remote technology meetings page, you said all members of the board and the public must be able to hear and observe, and each member can participate. So if a board has kind of like a YouTube listen only situation, would that be in violation of the open meeting law?
So the question is, if the board has a YouTube only view, is that in violation of the open meeting law? Not if they allow a means to participate, public participation. So email, other ways to communicate with the board, I think it would be okay.
So if it's listen only and you can't ask a question live. That's the real question, right?
Yeah. I don't know. I think you have to be able to allow for that, that public participation somehow.
Okay.
So I don't know. I'd have to know a little bit more, I guess, to answer that question definitively.
Tammy, go ahead.
Allows their members what was the question?
Question is, if the board has a Zoom meeting, allows the board members to attend via Zoom, but not the public. I think that the law requires, if it's remote, that it's available for the public. However, depends on the circumstances. You can have situations, and I've seen it done a lot, where a board member calls into a meeting, but the public's not allowed to call in. So there can be exceptions for how the board participates in a meeting. Again, that gets back to the agenda. What does the agenda say and how is the meeting being conducted? And so if the meeting's at a physical location, but a board member's in Washington, DC or something, nothing prevents that person from calling in, as long as the other board members and the public can hear what that person is doing. They are not required necessarily to be physically present. Doesn't mean that the violation of the open meeting law.
And just continuing, you talked about these public notice documents. How are those recorded? And this is similar. I've got other related questions to agenda and minutes. So are we recording? Are we recording or archiving things on electronic devices that are controlled by Lyon County, or are we letting Google control our archive of documents?
So how
Question.
that works, oh, go ahead.
Well, I was just going to repeat the question. So as far as the notice documents and how those are kept, is that kept on Lyon County information, or is it just kept on Google? Is that the question?
Yeah, are we archiving our electronic information on Lyon County servers or controlled by Lyon County, or are we using third-party servers?
Yeah, that's above my level. I'm not sure I know the answer to that exactly. My general understanding is that most of Lyon County stuff is done on its own servers. We do use Google for Gmail and other things, but it is my understanding that in addition, most of the data for Lyon County is stored on its own servers.
So if we store our emails on Gmail and someone makes an NRS 239 public records request, then assuming that Lyon County can get it, then it's fine. No, it's no issue. But that information is owned or controlled by Google, correct? That's my concern. It's just who physically owns the data?
Yeah, I don't know the answer to the data question. Go ahead.
Yeah, so IT has the ability to go and pull anything from any county email. So
Right.
that when we get those requests, we have the
If
ability.
they have access to Google. Right.
Right.
So
But we have, I believe everything gets backed up daily as well. So
By Lyon County?
mhm, yeah.
Okay.
yeah.
So we have our own independent archive on our own servers.
Yeah, I don't know specifically if all of the emails get backed up or not, but everything else does. So
Okay.
I don't know.
And so I will follow up, but I think those we're guessing at those answers. So I don't want everybody to say, okay, Lyon County
Right.
has all their emails back for whatever, because
And-
yeah, so those are probably better directed to IT
Well,
to get the definite answers. I do want to say a couple things on the email, though. Email can come up in the open meeting law context, certainly. Because you communicate and it becomes relevant to your decision, so people may want to see that stuff. And so sometimes board members think if I'm doing it on my private email, I can do whatever you want. If you're a board member, not true. There are times where Erin's going to say, send me your emails. So just be cautious of that. You avoid public scrutiny if you're a board member or public official by doing stuff on your private email. And so that's just something to be aware of. As far as the county emails and stuff, those are searchable for a number of years. You can't delete them. The county still has access to them. They can do searches, all that kind of stuff. I'm not an IT guy, so I don't know all the rules of that, but I can send a
Yeah.
request to IT. I need you to search these emails for these people. And for this time period, this item, and they do that search, and whether the email's deleted or not, we can usually get that.
Yeah, my larger concern was that technology is moving faster than the law. And
Yeah.
so what are the NRS provisions? Are they keeping up? Et cetera. So,
Yeah, no, I think the answer to that is no.
yeah, exactly. Okay, two more quick questions. On your agenda also includes page, you said should include statement for additional assistance for physically handicapped. Does that mean it's not required?
I think it's required by not the open meeting law as much as probably federal law.
Okay, thank you. 88. Yeah.
Yeah.
All right. And then you had two options for public participation, beginning and end, and then for each agenda item. And you mentioned how, for example, the county commission allows both, does both, but they're not required to do so.
Right.
Okay, so they either choose, they are required to do either or.
Yes.
Okay, so if they do agenda item only public participation, then the public does not then have the option to talk about anything. Is that correct?
Well, yeah, I think generally speaking, it's going to be a public participation beginning and end.
Right.
As the option, because that's the only way it really works if you don't let people speak on each agenda item. And so, yeah, the public participation in that context is open to whatever, including items on which.
But if a board chose the second option, which is only speak to each agenda item, then the public would be required to speak only on that agenda item, correct?
Yeah, which could be an issue.
Okay.
In the opening.
Okay, right. Thank you.
Again, depends on the circumstances, but that could be an issue. Yeah, Stacy.
I'm a little confused on the committee as a public body. So if if you have a committee meeting and you don't have a quorum, why would that be subject to the open meeting law?
Yeah, so I think it's everybody hear the question. If you have a committee, it's not a quorum. It doesn't even involve maybe it's only one board member or something and other people. Why does it bring up the open meeting law? And I think the problem they ran into and the reason they made these changes is boards were pretty quick to appoint committees. Committees go out, do a bunch of work, bunch of research, come back and say, this is the way to go. And the board says, great, vote to approve it. And the public has no idea how they reached that decision because the committee did all the legwork, all the information gathering, all that kind of stuff, and did the work for the board. And I think the reason they wanted that is they want the board to be open about why they're making their decisions. And they viewed committees as a way to circumvent that. And so that's why I think the change was made. And that's why boards now, they still appoint committees, but they're subject to the open meeting law. Doesn't mean the committees don't meet and do all the same stuff. The public just has a right to participate in certain circumstances if they're going to be the one primarily making the decision. Does that make sense?
Yes. And then I have, so is it acceptable? You said like the board members shouldn't discuss outside, but being an elected official, is it a problem for me if I wanted to go and get an opinion from each board member on something that I would like to bring up in the future? Is that
Okay.
as long as I don't share what the other person said or by email, like just a discussion, I would like to do this and I'd like to know if it's feasible. I'm learning a lot and doing a lot. So, having their input, them being in the position for a while is very helpful for me. So it's like, I'm thinking about doing this. Is this something that you think is plausible?
Okay, so the question is, you're elected official, an employee, and you want to meet with the board members individually or one board member, whatever, to talk about a certain issue that's of importance to you, is that allowed? Yeah, under the open meeting law, that's absolutely allowed. Staff briefings, communications with board members are permitted. So Andrew, if he has an issue coming up on the Dayton Regional Advisory Board, he can have a staff briefing with every board member. What he can't do is tell you that board member 1 told me this, what do you think about that? Board member 3 told board member 2 this, what do you think about that? But he can definitely brief each individual board member. Stacy can talk to each individual board member. We have a, you know, a clerk treasurer issue. I need to just let you know this. What do you think? That's totally allowed, not a violation. Only if you are working toward making a decision. So staff briefings allowed. Yeah. No, go ahead.
What I was gonna say though is that you might want to be careful about polling each one individually, especially if it's going to be something that will be on the agenda. Because that could be seen as predetermining an outcome.
Well, yeah, not asking about how they would vote, but, you know, is this something
Yeah.
that, you know, if I'm leaning, you know, I'm looking into maybe, you know, proposing this to, you know, a change in something or an ordinance or something that may affect my office or going forward, just kind of understanding if it's been brought up before, not, I mean, being new, you know, is it, I can search the ordinances, but oh yeah, we voted on that 2 years ago, so no, you know.
Yeah, no, that's absolutely appropriate. Yeah, like I said, you just want to be careful about, hey, how would you vote on this if I brought this forward?
Okay,
That
I
might
could not do that.
not,
Okay.
might not be good.
Everybody hear Andrew on that follow-up? Just, you know, don't be pulling the board members if you're speaking to them. And the other thing comes up a lot for citizen advisory boards, other board members is, you know, members of the public want to talk to you. And your public volunteers and officials, that's part of your job. I mean, certainly that's not a violation of the open meeting. It's what you do in response to it that can cause you problems. But yeah, I know as you all have to deal with the public, and that's just part of what you need to do as a board.
Did you have a question?
Yes, I have a
Yeah.
question. So the committees are always subject to open meeting law.
Not necessarily always. Question is, are committees always subject to the open meeting law? Not always, but I think I had a slide in there with the law, which is pretty broad now. That if it's 2 or more members or employees, it's probably going to be subject.
If it is giving advice or
Oh, yeah.
to do tax.
Yeah. Giving advice or to the board.
So a follow-up on that. So all the requirements as far as posting an agenda, backup material, public participation are required for that committee meeting?
Yeah, if the committee is subject to the open meeting law, then the notice requirements are identical.
Okay, thank you.
For that committee.
Just a quick follow-up. Just a quick follow-up on that. Agenda and minutes, presumably, correct?
Yes,
And then I see emergency meetings occasionally, different boards. Are all of the same laws and regulations pertain to anything that's called emergency meeting as well?
so 2 questions. I don't know if everybody heard them. First one is committee is subject to the open meeting law. Same requirements, agenda, minutes, meeting location, all those kinds of things. Yes. Same requirements as any other public body.
The only thing that changes is the posting requirement time, because it's considered an emergency. You can't have an emergency and then post it 3 days later. Because then that would change the definition of if you're having a regular meeting.
Yeah. Second question was emergency, and did everybody hear Erin answered that question? If it's an emergency, the 3-day notice, the other requirements do not apply because it's just not feasible. If it's an emergency, you're doing it that way because you can't do it within the time frame. Example would be the county commission just declaring an emergency with the flooding in January or whatever.
There likely won't be any instance where I don't think there would be any instance where the advisory boards would be declaring an emergency meeting.
Yeah, that's right. And also I don't talk a lot about closed sessions. Sometimes people ask about that. closed sessions at the advisory board, there's never a need for a closed session. And so we just discourage even discussing that. The one thing that can come up though for the advisory boards related to that is sometimes if you're discussing a person, you can't discuss that person's character, mental, physical condition, things like that. So just stay clear of that. Just avoid, if that discussion comes up and you're the chair, just shut that off. That's not appropriate for the board. If you have issues with a board member, those kinds of things where maybe some of that is related, that's when you want to reach out to Erin or Andrew, let him or her know what's going on, and they'll guide you through what that process looks like. It's usually not going to be resolved by your board. That's going to be something that's taken up in the county manager's office and dealt with in a way that protects any privacy issues and keeps that board out of trouble with the open meeting law. Yep.
You had mentioned earlier, she had mentioned the conflict of interest or talking as a public person. So if you have an agenda item that it involves you personally, yeah, lot splits, whatever, can you just recuse yourself and step out as a board member at that time, and you can participate as a public because you're not voting? So you have your comments on the record?
Yeah, the question is, if you have a conflict of interest, can you recuse yourself and then just step out and be a member of the public? The answer in typical attorney fashion is it depends. And you do, I'm going to say, when you become a board member, as all you board members know, you give up some of your public rights. I mean, that is just the nature of the business. And if something comes before that board that is a conflict, it is cleanest if you say, man, I'm out. And you just leave and you let the board do its business. I know sometimes that's very difficult to do. It can affect your personal interests, but that's the cleanest advice for sure. And there are times where you can't do that. I understand that. Contact Erin, let her know the circumstances, and we'll work through it. But if you have a conflict of interest and you can just let the board deal with it without your involvement or input, that's going to make it cleaner, because people are going to see you up there making a pitch and they're going to think that's just the fellow board member. They're going along with him or her. And it just creates issues that maybe don't benefit you personally and certainly don't benefit the board. And so that's a tough decision. But on a case-by-case basis, we want to deal with those. That I know that's not a yes or no answer you're looking for, but I think that's the best.
That's an
advice I
attorney
can
answer.
give.
It's good.
It's a case-by-case. Talk to the DA's office, talk to Erin, Andrew, and decide on that particular case. Is this a good one for me to speak as part of the public? And it does happen. I mean, we see it not frequently, but there are situations, planning issues a lot where, one of the board members lives right in an area where there's a project, subdivision, industrial development coming in, and they really want to speak for or against that. It affects their property interests, property value, whatever. Those are important things. We understand that. We want to make that happen in a way that's fair. But sometimes that means telling you can't participate at your own board. You need to participate at the county commission, or you need to participate at the planning commission, or you need to meet with the planning department, whatever it is. Sometimes it's going to be us telling you don't make a presentation to your own board.
So when we adjourn for the cemetery board, are they still under open law,
Yes,
open meeting rules?
they are.
Okay, and then the last thing I got a question. If the board figures that it would be better for us to meet on a different night and different time, can the board make that choice?
Yeah, so the question is, can
So
you,
it's consistent with instead of the first Wednesday after the first Tuesday after the third Friday. So that you can just, the first Wednesday of every month is going to be your meeting.
yeah, so can you, the question is, can you change the time of your meeting? I'd give two answers to that. One is, yeah, there are times in a given month where you want to change the date of your meeting because maybe there's a school event, maybe there's a 4-H event, or there's some other activity that everybody wants to be at, county commission meeting, whatever. I think on that instance, you can, if you do it properly, you can change that date on a one-time basis. If you want to change your meeting date permanently, you meet on Wednesday, you think, it's better for our community to meet on Tuesday. You can do that, but that needs to be done through Erin and the county manager's office. We need to make sure that if the bylaws have information on a certain meeting date, that that's approved by the Board of County Commissioners and that that process is accomplished.
Okay.
But that's certainly doable. We want to make sure that your meetings align with the county and more importantly with your community, so you get the input that you need at your meetings. If you know that if there's a conflict constantly every month, because your meeting conflicts with something else going on in the community, that needs to be changed so your meetings are productive too. Okay. A couple on the Zoom here, Gina,
I have one additional question.
let me do a
sorry.
couple.
Okay, do a couple Zoom. then.
I've been waiting with patiently, so let me just do a couple quick Zoom ones and then we'll get on to.
Thank you. So I have two questions. So one is, if people are requesting the agenda, I believe it's is it okay for us to just refer them to the website where they can go and get and select notifications and they can be notified when an agenda comes out?
I need to check that. I'm gonna have to let you know. I think it is okay to say that it's available on the website. We may have to also email it and in certain circumstances, mail it. But let me check the answer and let you know on that, Gina.
Thank you. I have another question as well.
Yeah,
You mentioned that that the minutes need to be available within 30 days, even though they're not approved at that point. Where would those physically be that you would consider them to be available?
Steve, your mic's off.
those would be with Erin. I think all the minutes are provided to Erin. So they would be available to her.
Right, but normally we send them once they're approved after the following meeting.
So
Yeah.
if they're being saved within the Google Drive, your draft minutes, and someone emails me and I said, hey, do you have the draft minutes available? Then I can easily pull them out of your Google Drive. If I don't, if they're not saved there, then I would have to contact you to be able to give that to them.
Okay, that answers my question. Thank you.
Yeah, and just to comment on the minutes, the minutes rules are not designed for citizen advisory boards or boards that meet monthly or less frequent. And so that it makes it a little bit challenging, especially for some of the boards that maybe meet quarterly, things like that, that the draft minutes just need to be done. We understand they're not going to be approved within 45 days or whatever, because there's not going to be a meeting. And so we just try to work around that with following the rules, allowing the board to still, approve the minutes, but making sure that they are available within the time required by the open meeting law.
Thank you.
All right, Stagecoach GID.
It's not set up.
Oh, you can unmute yourself.
Yeah, they should.
Is
If
some,
you hit your space bar, or if I remember right, it starts 6.
is somebody there with the Stagecoach GID?
Maybe not.
Can you hear me now?
Yeah.
Okay. So my board would like clarification on if they vote no, do they require an explanation?
Good question. I think Andrew's going to get into that a little bit with the planning items. The general answer is if it's just a regular agenda item, no, you do not have to provide all your reasons. There are exceptions to that don't necessarily deal with the open meeting law, but they deal with some due process issues and other things like that. So we, as a general rule, no, you don't have to state your reasons.
Okay.
The main issue where that's different, which comes up all the time with the planning commission or the cabs, is planning items. And I think Andrew plans to speak a little bit about how those items are handled a little bit differently.
Okay. And the other question they have is, we have a 5-person board and they want to know if the chair has to vote on each action or only in case of a tie.
Under the open meeting law, with the GID, the board vote or the chair votes on each action. There's not, sometimes the city, the mayor may not be a voting member unless there's a tie. That's not true with the GID. The chair votes on each item.
Thank you. And that was my questions.
Okay.
Thank you.
Any other questions? Okay.
So mine goes back to a disruptive or attacking, not physically, but verbally attacking
Yeah.
person. So we had one at our last meeting that was kind of verbally attacking a member of the in their comments of the Lyon County Fire. And I did hear a question in his attack though, so I didn't ask him to be removed. I know that's always tough when you have, because people are passionate about some of the issues.
Yeah.
And I just banged my gavel and asked if he had a question. And then he did state a question, kind of said, but was that okay? Or did I curtail his public comment by just saying, do you have a question?
Yeah. So I don't know if everybody heard the question, but have a member of the public discussing an item being abusive and caustic and disruptive. And the chair pounds the gavel and says, ask your question or sit down. Is
I
that
didn't
a
say
vi-
sit down. I just
know.
said, do you have a question?
You should have said, ask your question or sit down.
Oh.
Yeah, that is not a violation of the open meeting law. Totally appropriate. And you can do more than that if they're being disruptive and abusive. You can ask them to leave or have them removed. So anything less than that is fine. Great way to handle it is stop them, stop that person and find out what they want to say, or if they have a question related to the topic. If not, then they can just move on.
Okay.
So I think you handled that just right.
Okay. I just wanted to make sure I wasn't curtailing his.
Yeah.
And then the last one is, so on the recommendations that a board does for approval or denial, what is actually done with those? I mean, I know they go to the Board of County Commissioners. Are they given to them beforehand so they can read them the morning of the meetings? Is there any, I'm just kind of,
Yeah.
what's
So
really done with them?
I think Erin may speak briefly to that, but my understanding is, yeah, your recommendations always come to the county commission or the planning commission if it's feasible. With the planning items, there are timing issues, as all the cabs know. By statute and other things, you're not always allowed, the timing always doesn't work out. So the planning commission may not have your recommendation timely, but if they get it the day of the meeting, they're going to give it to the planning commission. They're going to give it to the county commission. Any recommendation you want passed along will be given to them, usually in the agenda packet on all items. And if it's not in the agenda packet, Erin's really good about getting those the day of the meeting or whatever it is and making sure the board has them.
I just have one follow-up question to that, sorry, because
Yeah.
I know in the staff report that they get, and this is planning item specific, they get items that say, the planning commission voted, recommended denial or approval. But in a lot of them that I see, that a board may have recommended denial or approval, they never even mention it, whether, like they don't say the CAB recommended approval for this item. Are they required to? I guess that's kind of what I was getting at.
Yeah, question is, are they required to state on the record what the CAB recommendation was? No, they are not required to do that. So a lot of times it is. I know on the planning items in particular, usually it'll, it's referenced which way the CAB recommended, either in the staff report, staff presentation, or by one of the board members, but they are not required to do that. It is information just like any other information before the board. We've all seen it. A board can make a decision with little or no discussion. They can just say, we vote no, without a lot of explanation. Not a violation of the open meeting law or any other law that I'm aware of.
Just a quick follow-up to Amanda's question.
Yeah.
So what's the difference between voting down a motion to approve and voting for a motion to deny?
Question is, what's the difference between voting down a motion to approve and voting a motion to deny? Generally, not a lot of difference. It would both be a denial. It can be a difference, though, in a planning item. There are certain requirements in the NRS regarding planning items that they have to be approved or denied within a certain time period, or they are deemed approved. And so a lot of times, even with non-planning items, the county commission or something, you'll see Andrew ask for another motion. Motion to approve, seconded. Call for the vote, it doesn't pass. So it's not approved or denied technically. It's deemed a denial, but a lot of times like Andrew would get up and say, is there another motion? And one of the board members would move to deny or something like that, just to clean up the record. Not required, but usually recommended, if that helps. Okay. So yeah, I went a little longer than expected. Sorry about that. I appreciate all the questions. Maybe take a 5-minute break.
Yep.
Erin,
That'd be good.
take a 5-minute break and then Erin will get started with her presentation.
Please take your seat so we can get started.
Well, I'm really glad that we're all here today. I know that we have a lot of information that we've been throwing at you, a lot of documents, concepts, training. What we're hoping to do is that by giving you all these tools, we're giving you information to utilize for your meetings and for you to be successful. I don't know how, why isn't it going? So as you're going to notice a lot within the advisory boards, the Board of County Commissioners, the Planning Commission, all the information you're giving, everything's going to work in a cycle. Everything comes together in one piece. So as Steve just went over the open meeting law, I'm going to touch briefly on how the bylaws, ordinances, and CAB handbook and also resolutions affect how your boards work and how you take all this information and we utilize it into a process and procedures. Why isn't my clicker working? There we go. So in NRS in chapter 241, that's the chapter for open meeting law that we just reviewed. This section tells us what we should be doing and what we should not be doing. Some of it's informational, it gives you a how, but not always a how to get it done. So that I think when we come together with our bylaws, our resolutions, and our handbook and the open meeting law, the handbook that they give you, it's not the open meeting law handbook, manual, gives us more direction and brings it down to a better scope of work so that we understand how to utilize all of these requirements and how to do our jobs. So in county code, and for the chapter of the Citizens Advisory Boards, the commissioners approved an ordinance that says that they can create the Citizen Advisory Boards and what of their scope of work, what they need to do. So it creates all the advice, like they can create the Citizen Advisory Boards. And then it also says in that ordinance that they must create a bylaw. So the bylaw tells you how to operate your board. So you take an ordinance that says they can create this board. The bylaw says, this is what we want you to do with this board. The resolution that the county, I'm sorry.
Can the bylaws be different from advisory board to another advisory board?
Yes, depending on what the advisory board is or committee or what have you. So in resolution, a resolution is when you take a very long detailed motion and you put it onto a piece of paper. So the Board of County Commissioners created a resolution for every single citizen advisory board. So that created your geographical areas and some of your other expectations of that board. So the length of the complexity of a resolution is a motion. So with all these things, we have the CAB handbook, which also the commissioners approve, the bylaws, open meeting law, ordinance, and resolution. All of these things work together so that you guys can practice on your boards. So if you haven't reviewed your handbook at this point in time, there's a lot of different aspects to the book. It reviews what your expectations are, what our expectations are in the county manager's office. It reviews that the chair is the person who is a primary contact. While sometimes some of those duties are designated, ultimately, the chair is always the person who's going to be in control of the meetings, their documents, and the overall procedures of that board. So as you all work together from vice chair, chair to secretary, the chair is always going to be ultimate person, the point of contact in all things. Part of your job as an advisory board member is also to work with the community and gather information, and then go back and communicate with your planning commissioners and your board of county commissioners. So as an advisory board member, your goal is to interact with your community and bring back information to us so that the commissioners can utilize that information to do their jobs. Members are in a staggered 2-year terms. I know this gets kind of confusing at times. So every couple of years, we're going to have someone's term end up. But if someone leaves early and we have to reappoint that person, they take over that term. It doesn't restart. So the terms stay the same. As Steve was going over earlier, you are a volunteer, and that does have some hindering responsibilities that can feel complicated, and it can be very time consuming and also be very knowledgeable and skilled. So that's why we're here today, is to help you get this information and to help you feel comfortable doing what your responsibilities are. So I wanted to touch over what the board responsibilities are for each person that you appoint. So we have the chair. As I was mentioning earlier, the chair is responsible for all the document retention requirements for the year. So if you designate your secretary to help you by the end of the year, when I say record retention's due, I need you to go back and check to make sure that it's done. You have to check to make sure that your secretary did the work. And you also have to understand what your secretary's job is so that you can understand if she did it or he or she. The chair is responsible for facilitating board meetings. So not only are you responsible for starting the meeting and going through the flow of the meeting, the chair has to be the spokesperson to make sure that everyone's point gets across. So you have to be like that nonpartisan person to help the flow of information between your board members. So you have to be that sounding board to keep things cool and calm. And also to ensure that everyone on your board has had that moment to speak. As the chair, you're responsible for understanding that the documents that you're submitting to us are clear and they're correct. So if you're submitting an agenda and your secretary or vice chair is helping you put it together and she forwards it to you, it's your responsibility to review that, read it, and to collaborate with her to make sure that none of the wording needs to be changed, to make sure that your board is moving forward in the directions that you want to do for that meeting. And then once you have deliberated that with whoever your secretary or vice chair is, then you would push that over to me into the email to ask me to post it. We do ask though, at that point, if you need help with the wording on your agenda, send it in even earlier, because we don't want to get to the point to where, I'm sorry, I'm not posting this because we need to reword this item, or we can take it off. So we want to work with you before we get to that point. So if you ever need help, give us extra time so that we can give you that. The chair is also responsible for email and correspondence. If you want someone to come into your meeting and to do a presentation, the chair is responsible to make sure that that person is there. You can delegate the task to your secretary, but ultimately the chair needs to make sure that he's responsible to understand what's going on in his board and that he's being part of that process. So if he wants to delegate it to his secretary or his or her secretary, fully they can, but they need to be in communication with that person to make sure that these tasks are being done and complete. All the same thing with the email correspondence. I'll touch on the fact that when you are sending an email and you're using your private email, which sometimes happens, if you're going to send an email, make sure you at least add your advisory board email so that it's CC'd in there. I know that it feels time consuming to toggle in between your emails, but we do that for your protection because we don't want your personal email to be involved in your board business. And also if we have to go back and look for anything for minutes, agendas, anything like that, we want that record in your emails and not your personal. As part as the chair, we like for you to come to the board meetings if you have time and give reports to the board directly. They're in charge to make sure that they are in communication with, in collaboration with the Board of County Commissioners and their planning commission when they feel like they need to reach out to them also. So the vice chair, what we have started in a practice is to make sure that the vice chair understands the roles and responsibilities for the chair and also the secretary. As some of us sometimes are sick or we have personal things that we can't make a meeting, we'd like to have a personal backup to that person so that they understand what the secretary role is so that you're not blindsided when you get to a meeting. So if you haven't already started doing some sort of cross training with your vice chair, I'd recommend you start doing that. And then that way you have more hands on deck. You have more people that have knowledge of understanding what are in these minutes, why are in these minutes. You have more knowledge and more skills and make you more successful. During the meeting, the vice chair and the secretary as you can imagine, when you're running a meeting, you have all these topics and these things that you need to review and discuss. It can be kind of distracting, or you're thinking about another point you need to get to, and you may forget public participation, or you may forget that someone didn't make a second, or you didn't get a vote. So the vice chair and the secretary is also supposed to sit there and make sure that you're following the processes and procedures of the meeting. So the secretary is the go-to person. They pretty much know everything that the chair and the vice chair need to do. And they get everything ready and put together in a nice clean bow and ready for the meeting. So this person's like the workhorse of the board. They help review pretty much everything that needs to be done, put it onto your agendas, into your minutes, make sure that everything's, your retention requirements are met. This person, give them a pat on the back because they deserve it. So the secretary helps facilitate the meetings, drafts the agendas and minutes. She turns those over to the chair. If the chair is absent, not going to be there, then she would turn it into the vice chair for him to, or him or her to review. So as we just mentioned before, that you can delegate these tasks to her of the record retention and the email and the correspondence. But like I said, the chair really needs to make sure that he's involved in these practices and procedures because we don't want something to be missed. What we found is when one person would leave the board, it would leave a gaping hole, and then we would have to start training all over again. So the more that we work together as a board as a whole and everyone understands each other's jobs and descriptions and their duties, in case of a situation where someone's not there, there's always going to be that other person to back that person up. So interactions with the county manager's office, that's mainly me. What basically my job description is to give you the information or to get you to where you need to be to do your job. When we also provide supplies, it's limited, and that usually it's paper or ink. If you told me you need more pens, I would send you more pens. If you need more nameplates, I'll send you more nameplates. If you have an issue to where you don't have a computer or printer, I can find either a library or a building such as this for you to work from. We do not provide computers or printers at this time, but I can try and find the best way for you to get your jobs moving and done. So also I facilitate the flow of information. So if you send in a letter of transmittal to us, I make sure that it goes to the correct person. So sometimes it's not always the Board of County Commissioners that you want to talk to. Sometimes you send in a report to me and it needs to go to Dustin, the road department, before it goes to the board. Or I need to send it over to Andrew for review before it goes to the board. Sometimes your interactions aren't always with the board. Sometimes I'm going to find the correct person for you to talk to get the information that you're looking for. So I also monitor and post your agendas. I know I bug all of you with your wording, and I probably have exhausted the fact that you probably don't want to email me anymore. But the reason why we've been really strict with that is because we want to make sure that you're learning and displaying a positive and getting that flow of information to where we're trying to prevent anything that's written on your agenda from being an issue for you. And I'm also trying to teach you the best that I can. And it's not something that's supposed to be meant to be a disciplinary action or feel that way. But if I make a recommendation that we need to change something on that, it's because I'm looking out for you and I'm also looking out for the county. So if I ever come back to you and say, what does this mean? What are you trying to do? What can we do to reward this? That's why. or if I come back and I ask you to redo something on your minutes, it's because I want to make sure that you're developing the correct processes and procedures and you're learning that. If I'm not helping you, and if I'm not giving you a correction, it's not to be disciplinary, but just to give you that information so you understand what you're doing and how. Since the change of the open meeting law requirements and the posting, minimally, it has to be done at the governing body. So that would be our office, online at the Lyon County, and then the state office. Since you're not the one that's doing that anymore, and I'm the one that's keeping the record for the notice of posting. Does it make sense for you to fill out something if you're not doing it? And that's not how it's supposed to be done anyway. So best practices on your side from what we need is this one too. Okay. Is a 2 weeks notification of staff attendance. So if you know that you're having something on your agenda that could be a contentious issue and you want the sheriff to be there, we ask for you to give him a minimal 2 weeks notice, because if he can't make there, he has to ask someone from his staff to be there. And it's just a common courtesy to give someone some notice so that they can rearrange, because usually your meetings are after work hours. So they have to find someone who has to take usual personal time off to be there. Utilizing the Google Docs, the reason why we started doing this was there was a gap in what was electronic files to we had members who were very consistent on being on the board. And so they had everything backed up on their computer. Well, when they left, it was killer to get all that information back over to our office. Our office is required to maintain all that, the legal documentation. You're not supposed to do that. Our office is. So if I don't have that information, I'm not meeting the requirement goals for record retention. So we developed the Google Doc system, and that if someone on the board who is retaining those documents leaves, I already have access to all of them and I don't have to worry about not getting them. Also, if I'll pick on Stacy, say Stacy's on the board with me and I'm not going to be there and she needs to make a draft agenda and she needs the newest form, she can easily get it because that's a shared drive. So that was the second idea behind that. We ask everyone to email your agendas at least 4 days prior to the posting cutoff days. Legally, it's 3 days we have to post it. But if you email me your agenda at 8:30 and I have to post it by 9 o'clock and I'm talking to someone else or I'm on the phone or I don't see your email or I have to go into a meeting, it may not get done and you're not going to have your meeting. We're going to have to cancel it. So we ask at least minimally 4 days prior, not including weekend and holidays. If you want a more technical review, it has to be prior to that. So if you feel like you need to give me some information, you want some feedback, 5 or 6 days before your meeting so that we have time to review and go over some things together. I always say get more time is better, because even though you submit it and you don't think you want my review, I may still come back and say, hey, we need to touch this up. And the reason why I don't do it for you is two. One, I want you to learn what you're doing, because if I'm doing it for you, you're not part of the process. You're not learning it. Two, I want to make sure that whatever record that you have in your Google Drive and the one that you're sending out is the exact same thing that I'm posting. So there's 2 reasons for that. If at any point in time that you know that you're going to cancel your meeting, it is your responsibility to give me a cancellation notice. So say, hey, Erin, I'm going to cancel my meeting. I'm gonna say, that's great. Can you send me a notice of posting? The reason why I do that is, for one, you're going to have to notify your board members that you're canceling it. I need to post it online. I actually put the piece of paper online. So if anyone does sign up for our electronic services, they get that message. And two, it gives us a clear record of when you're meeting, when you're not meeting, what minutes you have, what audio you need to have. So there's those reasons that we ask you to make sure that you're sending that in to us. Every month after your meeting, we need you to be diligent about when you send in your final minutes to make sure that your audio is also being saved into the Google Drive. So at the end of the year, when I ask you, is all your record retention requirements met, and you say yes, I go and download all of your audio. I already save all your minutes, but I go in there and I check to make sure that all your audio is there and I retain that for you. So I ask you to do that monthly because if you don't get in the habit of creating a consistent pattern, you may miss something. So when you're doing your record retention at after the meeting, do all of it. And yeah, and I just want to know that turn in your final meeting minutes. Sometimes someone will send me their draft minutes and I say, here, here's my draft. And I say, that's awesome and great. I'm glad that you did them. But what do you want me to do with them? If you want me to look at them, review them, more than happy to go over that with you. If you want us to save them, there's not a whole lot of information we can do with that. The only time that we really need your minutes is when they're in the final form. So if you need help, let us know. If not, the only time that we need your minutes is when they're final. So also lastly on this one is we need you to be corresponding and have a better relationship with your Board of County Commissioner members. So if it is someone within your district or your area, reach out to them. If you have a question about an agenda item, we encourage you to email them, talk to them, get that relationship going with your Board of County Commissioners. They would like for you to come in and do your reports monthly, if you can. I know some of you work, so that's not possible, but they would like to see your faces there. So
Ask the question on the cancellation.
could you grab a mic?
Yeah,
for
you
this
should
one?
be able to get that out now.
I just don't know if people want to well.
Okay, the cancellation notice, what is, Smith Valley's been hammered with snow and driving hazards this year tremendously. So we have already had to cancel one meeting. Is there obviously that's an emergency situation, so we don't really have a foreseen cancellation. So is there some kind of time requirement? We have to notify you of that?
As soon as you know.
Just as soon as we know?
Yeah, and I'm going to go over the 3 different types a little bit later on. That might help you answer that a little bit more. But as soon as you know that you're going to cancel your meeting, you need to start getting that. But I'll go over those scenarios and then if not, you can let me know. So part of non-compliance is not turning in your monthly minutes. We know that it's a requirement that they have to be at least drafted within 30 days, but as soon as they're approved, we need them turned in because when we post them onto the Lyon County website, it sends out an electronic message to those who get notifications that it's been posted. And then it's also available for the public online. We do not want you using your personal emails to correspond. So if you want to set up time with someone to give a presentation, do not use your personal email. Use your CAB email to do all board business with. There's some months to where you may not have a meeting. Whatever that situation may be, but it needs to be a pertinent reason to why you're not meeting. If that should happen, then that's okay, but you just don't want to not be meeting because you're just not participating on the board. A really important part of when you're doing the minutes is if someone is not on or not participating or they're absent for your board, you need to write that they're excused or not excused. Because if that person has a habitual situation to where they're not showing up to the meetings, per your bylaws, if they miss 2 of them and they're unexcused, then that gives us a reason to remove them and find you a better board member. If you don't put anything on there, then we don't have any teeth to help you. Not part of not your non-compliance is not communicating with your Board of County Commissioners. So if you have a letter of transmittal that you need to get put across for planning, some other required document that we want back from you, and you choose not to do that, that would be considered non-compliance. We all know that you guys are all here today, so great, you got your compliance done for your training, but since it's such a labor of love to be on these boards, we need to make sure that you have the information. So missing trainings is part of that non-compliance. In your emails, I know how we have it set up, not ideal, because we have 1 email per advisory board. It also would not be very good to have an email for every single person on the board, because then who does that person be able to contact that one person, right? So between the 2, it made more sense to have 1 email for 1 advisory board. The reason for that is mainly so that we have one direct communication. So your secretary, vice chair, and chair can all sign in. So you do not want it to delete any pertinent emails. If you get spam emails, go ahead and delete those. If it's pertinent to your board, do not delete your emails. You can archive them or put them into folders if you wanted to organize them, as long as everyone on your board agreed. But do not delete pertinent emails, so that if your chair should come on after the secretary and he needed to look at something, if you deleted it or archived it, he wouldn't know where to find it. So make sure that you have that flow of communication of how you want that to be structured and work together. Do not reply all to emails if it has all your board members on there. So if you send out your agenda, don't, in the habit of, to all your board members, don't reply all and talk about the meeting, which Steve reviewed that with you. So if you have citizen concern and you got it in the email form, you can print that email and send that out or have that out for your meeting so that your other board members can see as part of that backup information. Or if the chair feels that they can just give a report, they can do that too, depending on what the information is. But if it's pertinent that the board needs to know, the chair needs to make sure that that information within the email is being shared. So if someone's coming in and giving a presentation, you don't necessarily have to tell your board someone's coming in and giving a presentation, because it's going to be on your agenda. If someone sends you an email to your personal email and it has to do with the board, forward that person to your CAB email and then respond. So you don't want to get in the habit of responding to emails if someone by chance knows you, because everyone knows Charles Shirley, you know, so they may reach out to Charles personally because they know him better personally than they do. So if Charles should get an email from his board, from someone from the community, he needs to forward that to his CAB email just to be on the safe side. So your Google Drive, has everyone found it at this point? I hope so. So your Google Drive is within. If you go into your Google email. Application. Application. It kind of covers them. If you go into your Drive, you have Google Docs, spreadsheets, do all kinds of stuff. But this is my Google Drive. What this looks like. And different folders set up. Google Drive is essentially saving things into the cloud. So,
Hey, Erin.
yeah. Can you hear me now? Okay. You can like keep an eye on the red dot for me. Okay. Yeah. So your Google Drive is what you're going to save into the cloud. So say you have your normal drive, and I don't know if I can show you on here, I can't. When you have your file folder and you can save it to your desktop, to your drive, to somewhere else. So when you save something in the drive, it's another drive, so to speak, to where you can utilize it the same as you would your computer. You're just saving it into a different location. You can still save something if you want. I know there's some people who are old school, they want it on their own desk, their own drive at home, on their own computer, their own device. That's fine. But when it comes to retention, it needs to be in here. And if anyone needs help, I can go over that in more detail after we're done today if you want. So now that we went over through the main parts of the handbook, I kind of wanted to go over when you want to start to draft an agenda. So I have this the handout for you. So the Citizens Advisory Board agenda. And then we're going to go over the agenda, how you draft it, how you finalize it, how you have your meeting, your draft minutes, final minutes, and your letter of transmittal. So as you see, there's a whole other circle that we just started. Again, so essentially your job is going to be the circle of life of how to get all these things done. So agenda requirements. When you go home and you're going to go draft an agenda, what are the requirements that we need to make sure that are on here? We already know that we have to, our posting requirements, not including holidays. But as we go through the list, we need to verify that A, we have the time, place, and location of the meeting. That's pertinent. If something is off on your date, say it's the year, not so bad, right? But if you have, say it's Tuesday, but you're actually put the date for Wednesday, what happens? Your meeting gets canceled because it wasn't agendized appropriately. We also need to ensure that where the agenda has been posted. So if you look on the second page after adjourn, it says this agenda has been posted in accordance with. So you need to make sure that it has the minimal requirements on here on your agenda. Clear and complete statements of all topics considered. Inform the public that the items might be taken out of order. So that is at the beginning of the agenda. On the header, it says to avoid meeting disruptions, the board may reserve the right, restrictions with comment. So if you do not have that notification on there, you're bound by doing things in order and not taking things out of place. So you don't have to have that on there, but if it's not on there, then you can't do that. As we discussed, we have public participation for 2 periods. We always recommend that those 2 periods be for anything that's not on the agenda. So when you get there, you can notify your public. This section is this public comment for 3 minutes. You go through all the wording, and then you can say this is for anything not on the agenda. If you like to speak for something that is on the agenda, please wait until that period. But if someone refused to do that, you still have to listen to their comment. To note the term for possible action item and for discussion. I know this is the for possible action for report only is a big topic. If you don't know what the for possible action is going to be on your agenda, don't put for possible action on there. The other thing is don't put for possible action and then give me a title. So we'll just say Mound House Community Center. What's your action on the Mound House Community Center? So you have to be descriptive if you're going to send in a recommendation for something to the Board of County Commissioners. What is your recommendation? So as Steve was giving us direction earlier, we want to have in that description what you want your motion to be, what the focus of the conversation needs to be. So in other words, a summary. So as we go to 1 on the agenda, call to order. 2, then we have roll call. We already have that on there. Okay, so 1, we have those out of order. So 1 and 2 should be flipped, but call to order, roll call, pledge of allegiance, public participation, review and adoption of the agenda should never be taken out of order. Whenever you're putting your agenda together, those items need to be there, and there's a reason for that. One, you always have to call the meeting to order. We have to verify that you have a quorum present. And we want to do public participation before you get to the review and adoption of the agenda. So if someone in the meeting should ask you, can you take this out of order? Can you remove this from the agenda? Whatever their request may be, that needs to be prior to your review and adoption of the agenda. After you get through the review and adoption of the agenda, we're going to get into like the body of the agenda. This is like the actual contents of your meeting. What are you meeting for? So you're going to 1, review and approve the minutes, any comments or reports, public hearing items, or for possible action items. At the very end, 7 and 8 are always there. So you're always going to have public participation in the adjournment last. So really, when you're drafting your agenda, you're going to save as your last agenda, copy it over, put in a new date, and everything within that body is what's going to change. So this is just a template that I printed out for everyone else. So if you were to then have also Zoom information, you want to make sure that that is right after this. So if after your, the name of your board has to be on there, the date and time, the location of your agenda, and then the Zoom information. So if you're going to meet physically and then also Zoom, you have to have that information together so people know where to find it. You need to have on your agenda the name and contact and or the cab email of the person of where people can get the information from off their agenda. So do you guys have any questions about drafting your agenda, how to start it?
Yes. So at the very bottom of that, it says this agenda has been posted in accordance with. Why do we want to list that at the end of the meeting? Why not list it like in item 4 or 5 or 6, something like that? To let the public know that we are in compliance before the meeting starts.
So did you, that's a pretty good question.
Because I noticed that's the way Scott used to do it. He'd read it into it like in item 4 or 5. When he would run the meeting.
I think an old practice, because he was the one posting it. Prior to like the changes in the electronic, whoever on the advisory board would be in charge of posting it, and then you would have to turn in your notice of posting. So I believe that's an older practice of that they would then resume and say, I posted it to these locations. It's not a requirement to notify the public though. I don't know if you guys have any additions to that one, but. Okay. Do you guys need any other help? Is there any other questions with, I don't know if I have anyone on Zoom, but if you guys do, just speak up quickly and then we can go over on to the next. Okay.
I just have a question on, so we added a future agenda items onto our agenda. Is that okay? It's not on we just added
Oh,
it this last
Yeah,
meeting.
you can add future agenda items if you wanted. On
Okay, it
yours.
would just need to be before the public participation at the end. Because
Yes.
right now we have it in between those, so we'll move it.
Yeah.
Okay.
Yeah. Okay, so with the planning department, the administrative assistant Shannon over there is also in charge of helping with the planning commission agendas and the backup material. So she's the person who sends out you a notification when there's a planning item within your area. She'll send, from my understanding, it's about a week prior to her meeting. She tries to get it out that Monday. Because of the time restraints, it's really hard for her to get that any sooner to you. So as soon as she gets it from the planners, she sends it out to you. She'll send you the information that you need just to copy and paste onto your agenda. So yeah. Okay. And also the staff reports, I know it has been hard for them to get those out to you on time before your agenda can be posted. If in fact that the staff report isn't available because of the time constraint, they will send you at least minimally the backup material from the planning application. So you have that at least so that you can have the backup information. The staff report isn't always available, but I know that she does ask the senior planners for it before she sends out emails and asks so you guys can have that information available. If that's the case and you don't have it and you have questions about the application, because it can be a very technical review, you can always reach out to someone on staff like Shannon, the planners, if you have questions about the application to give you some more background information. So again, that would be someone like the chair or the vice chair, or possibly the secretary that would reach out to her. But that doesn't preclude any of the other members if they wanted information. If you received that and you don't really know what something means, or you have a question, you need some clarification, you can always reach out to staff. Probably not me. Planning's not like my whole wheelhouse, but I can find the right person for you. So after you have your meeting, those reports and the cab and the secretary typically are those two people who work together to put letter transmittal together. And that goes back to the planning commission and back to the board of county commissioners for their review and part of their packet. Go ahead.
So, There is a little bit of misconception. So under NRS, the citizens advisory boards provide that advisory to the Board of County Commissioners. That's how it's worded in the resolutions as well. So now typically we do try to get that input in front of the Planning Commission, but it's not a requirement. So I know that question has come up a few times. So I just want to make that clear. If you guys provide it and we have it before the Planning Commission, before that item is heard, we will absolutely get it in front of them. But I just want to make everyone aware that's not a requirement. It is a requirement that that it goes to the Board of County Commissioners. So.
So advisory boards also do not approve or deny applications. While that wording may be a little bit tricky, we're asking you for a recommendation of, it's not an approval of. So you're not an approving entity. So because you're saying we agree to approve that this would be a good fit for our community, and these are the reasons why, or we are saying we deny this application because of these reasons why. So your approval doesn't affect the Board of County Commissioners or even the Planning Commission part of their process. What we're looking for is, why is this an approval of recommendation? Why is it not? So if you send us information that says we recommend approval, we're going to forward it, but it doesn't help the Planning Commission or the Board of County Commissioners to give them enough information to gather for them to understand why you came to that conclusion. So while your minutes may be limited on that information, when you send in a letter of transmittal or an email, we want a report of how you got to that. We want you to expand on that as much as possible so that they can better understand where you came from and why you arrived to that decision. So after you went through your emails and you put everything and you drafted it and you have your planning item on there and you're ready to rock and roll, looks great. You want to review, go back and review. If you, as someone in the community, were reading this for the first time, would you have any idea of what you meant? So you have to turn off your brain for a second and think as someone within the community. If you read what the actual content said, does it make sense if you read it for the first time of the action of what you want to do? Would you have questions about what you're going to do? So review your wording, and if you don't have the action of what you want the board to take, is it for report? Is it for discussion? If you don't have an action within that item wording, then it's probably going to be for a report or a presentation type item. So you want to then email the chair, if the chair is not the one drafting it, have him review and look at it, because ultimately the chair is the person who approves all your documents. If they review it and they read every single item, does this make sense of what we're doing? Then and if you want review from staff, send it to either myself. If I'm not available, Shannon can help you and read and review your items for you. And we'll be happy to help you with that, because what we want to do is to make sure you understand what you're doing and why. And if we don't get in enough time, like I said before, we may come back and ask you to make some edits, and that's just to help you to make sure that you're being successful in your meeting and we're not violating the open meeting law. If you do say have a planning item and they're going to come in and do a presentation, it is the Citizen Advisory Board's job to make sure that they're in contact with that person and that you make sure that they know when your meeting is and when they're coming. On the planning, I noticed that we had a little bit of miscommunication. We were trying to make sure that the developers know or the applicants know when a planning item's coming forward, and we say, hey, make sure that you get in contact with the Citizen Advisory Boards. And then we tell you the same thing. And so then they reach out to you and say, hey, can I get on your agenda? And you think it's that month. So you're like, oh, what's the wording? What are you doing? What we're trying to make sure you guys do is connect. But what we need to wait for is for when Shannon says, this is when I need you to put it on your agenda. So if someone reaches out to you, an applicant or a developer, and they say, can I be on your agenda? Say, yes, we will make time for you to be on your agenda. Let me follow up with the planning department to figure out when we're agendizing this. So you just have to pump the brakes for a minute and then reach back out to Shannon. And you can do that through the clerk's email to find out when that needs to be agendized. What I do is when I have something coming up in the future, I will start a draft agenda for that month. And I will make a notation there. So even though it may be February, March, it's March now. So even though it may be March and I have stuff coming up on the Board of County Commissioners, say in May, I'll already start my draft agenda. So I know what I'm doing that month and I can come back to it. So you can plan ahead. You can make draft agendas for the future, if that helps you. So now we're at a point, we got our draft done. Everyone's approved it. They loved it. So you're going to email it to the clerk's address, the county clerks at lioncounty.org, 24 hours prior to your posting cutoff time. I cannot stress this enough. Please don't give me a heart attack at 8 o'clock in the morning. Especially when I have like 5 agendas to post and the phone's ringing. It's awful. So make sure that you get that done early. Staff will respond. So the reason why we created the county clerk's email is if I was out of the office and I didn't respond and you're having a heart attack because you don't know if your agenda is being posted, no one's responding to you, there's someone in backup who can say, hey, your agenda's been posted. So if I'm on vacation or gone, then Shannon or some of the other clerks in Stacy's office is offered to help us to make sure that we get that done. After we have posted it to the board and the 2 websites, we will respond to your email and say, hey, we posted this to the websites and the board. That way that you know that it's done. And we respond prior to, as soon as it's done, so that you know that the notice of posting requirement has been met. And also ensure that that final agenda has been saved in your Google Drive. So virtual meeting requirements. Steve touched on a lot of this, so I'm not going to go over the gist of this, but we just need to make sure that if you're having a virtual meeting, that it's recordable, that the audio can hear the both sides. So whoever's on Zoom, whoever is present in the office is all recorded on the same recording device. Everyone can be heard. And that's the main thing that I just wanted to touch on that. Oops. So if you did decide as an advisory board, because we do have the licenses for your Zoom, they have been set up last year. I know some of you are new to the board, so you may not know that they exist, but if you did want to get to the point you want to have those hybrid meetings, you can. You may not be able to if you don't have the technology in your area, but if you have the technology, we can go through the steps to get you started. The chair, again, is a responsible person to making sure that these tasks are taken care of or delegated correctly. So if and when you guys are interested and you want to proceed to move forward, let me know and we can go through these things. The hard part when you're doing a virtual meeting is making sure that you're communicating on both sides of the story, right? So, for example, when someone's making a motion, not everyone can always see who's talking, so you don't always, and not everyone in the public can hear the voice or recognize the voice. So when you're conducting a meeting with virtual and even in person, you want to make sure that you're relaying that information along so that everyone is on the same page. So when you get to the motion part and we'll say Stacy made a first, Erin made a second, and the motion passed. So if I say, can I get a motion? She makes her motion, but no one can really identify who's speaking online. So after it's done, the chair should say, Stacy made the motion, Erin seconded it, and the motion passed 5-0, because I've seen it where the board members kind of give a yeah, but it's kind of low. And so if you're not really sitting and up front and present, it's hard to hear and understand because you don't, like, some of those sensory things are taken away from you when you're on Zoom. So the chair should always communicate all sides of the discussions and deliberations if there should be any questions. So if in fact that you're having a virtual meeting and some of the members are going to be participating virtually, you need to make sure that they're sent that information. So you're gonna have to email them that late backup. And then you're gonna also have to make sure you have your paper copies for who's in present. So if you're going to do something virtually, you have to make sure that the members have the information electronically and also present. Chat boxes are prohibited. Can't do chat because we don't want any deliberations or discussions going on during the meetings. And you can only schedule one meeting at a time. So that's just a Zoom thing. So you can't have two different meetings going at the same time. So if there's ever a discrepancy that if you sent out the incorrect link and people can't get on, you need to make sure that you cancel your meeting. And the hybrid meetings, if you get to the point where you want to start doing that, the chair needs to work with myself and we have to come up with the plan to make sure that all these requirements are being met and it's written so that we have a plan. And then we can do a test run and then you can meet. So conducting effective meetings. I don't know if you guys have heard of Robert's Rules of Order, but it's a really great tool to utilize in your meetings. We can use the content of Robert's Rules of Order. We can follow the heart of it, but ultimately open meeting law supersedes anything in Robert's Rules of Order. So I gave you guys a couple of handouts also through the email. So hopefully everyone has that. What's really neat about the information that's in this packet is how would you make a motion? How do you rescind a motion? How do you amend a motion? And also will help the secretary to understand how she collects that information and how it should be written out. So if you ever have a question and you're running in a meeting and you take this little cheat sheet with you, and you're like, someone needs to rescind a motion, you can look on here really quickly and figure out how you want to do that. But if not, it's just something it's a great tool to understand and use. The only thing I will caution you on is when you're in the meeting, and I've seen this happen and the board's up there and they're talking and deliberating and someone from the audience goes, point of order. Well, why doesn't that work? Because in open meeting law, it supersedes that. The public is not part of the board, so you can't yell out point of order as a public member. You have to wait till public participation. So there's some caveats like that you cannot use Robert's Rules of Order. What's really great. Oh, I thought you were just gonna say something. You have to get in the mic then. Yep, she's correct. So while we have, as I was mentioning before, we have those other documents like a resolution or bylaw. If something supersedes what's in Robert's Rules of Order, you cannot use Robert's Rules of Order over it. So if your bylaw says something differently, Robert's Rules of Order would not apply. It's also part of the secretary's job and duties to understand what those are. So the secretary has a lot, this is what I said, pat your secretary on the back, because she's also taking the meeting minutes, but she's monitoring. So whoever your clerk of the board is monitoring to make sure that these regulations, laws, bylaws, resolutions are being followed by the board. So she has, not only she's capturing what's happening for the minute, she's also monitoring to make sure that the board is doing their job. So simply put, Robert's Rules of Order is strictly defined procedures that can be applied to many meeting situations. And what's great about this is if your board isn't you're deliberating a fact, how do you deliberate that fact and do so in a professional manner? So this will give you the guidelines of how to do that. So if someone was to bring up the point of the argument, it tells you how to go through your board members so each person is heard and that their voice is heard accurately. And it's fair across the board. So everyone's heard and their points get across. And then there's just some other things on here. It talks about the officers, basic definitions, what the secretary does, what the chair should do, and how the vice chair helps in there. So I just wanted to bring these with you. They're a great tool to review and to take some notes on, but do review your bylaws as Tammy recommended. That's a very great point in this discussion. So during your meeting, you first check to make sure that you have a quorum, right? So you open up your meeting. So we're on our agenda. We call the meeting to order. After you call your meeting to order, what is the very next thing you do? You start and you say, this is the Citizens Advisory Board. It's Wednesday, March 4th, 2023 at 7 p.m. So basically on the audio, to the minutes, to the agenda, all these things have to work together. So everything that you capture on the audio, you should be able to replay the audio later and point and basically come together and say, this was the agenda. You should be able to then to type out what happened on the agenda by what you've recorded onto the audio. So that's why it's really important that your secretary keeps your chair on point. So you're going to then review. This is the date, time, location of the meeting. Then you get to, then you have to read into the record that you can take these things out of order if you put it on your agenda. Restrictions may be made by the public. And then you're going to do your roll call, right? So we're going to say, Stacy's present, Erin's present, Andrew's present, Steve's right present. Why do we do that? Because we need to have it on the record and people need to know that who's there and who's present. So we need to put the names on the record, one for the clerk, because what if you have a clerk come in who's helping and they don't know the names of the people on your board or someone's new to your board? So there's a couple of different reasons why we want to make sure that we're one, being clear and open with the public, and also getting the legal information that we're trying to put across that we need to make sure that we're capturing. So you go through your roll call and your determination of the quorum, you get to your public participation, you read that through, and you follow along with your meeting. So public testimony will be heard on action items. As Steve was saying, if you're going to do like a recommendation for approval on something, you want to make sure before you get to your vote, it's been seen to be a better practice is after you get through the gist of whatever information or you read your title in for that item, you get your presentation, you get the gist of what the item is to open up for public participation, then ask for a motion, and then go through that. If you forget to do your public participation, stop, correct it, and go back. So, okay, chair must report all email correspondence. So if you're going through and you did not have something on here that says for correspondence, make sure that you do have that at least printed and available under your correspondence item for your guys' agendas. So if you don't have it, then the chair has to read it into the record. So if you don't have the paper copy, it has to be read into the record. All speakers must identify themselves. I know it's really hard habit to get into when you're getting into like in the groove of your meetings, but if you're stopping and you're starting a new item or a new person's coming up to speak, please remember to identify yourself on the record, because if, say, not usually the advisory boards, but say the planning commission or the board of county commissioners, if that audio gets pulled and has to go into a legal court, we want to know who's speaking. And if we ever have to go back and clarify for the minutes, we want to know who's speaking. We don't want to make any assumptions wherever not possible. The chair can recess and adjourn the meeting with the, so if you get to the end of your meeting and your business is done, the chair can adjourn the meeting. If the chair is going to adjourn the meeting, under certain circumstances, if it's being disruptive or someone feels like the agenda wasn't clear and complete and they wanted to go back to something, it would then take a vote of the board. So as long as everyone should agree that you can go ahead and adjourn. You don't always have to have a motion with it. I know that's been a point of subject that I've been asked, but you can't adjourn it unless there's a discrepancy, and then you would have to go to a vote. So the chair must state all actions from the audio to the minutes to be accurate from what's on the agenda. All these things try to align as much as accurately as possible. So as we've been talking about, Robert's Rules of Order is a great resource, but it doesn't interfere with open meeting law or your bylaws. What's really great about it is it does help to bring discussions to closures. Board office. All the part of Robert's rules, always follow.
Before you get into the meeting minutes, can I touch on how that? Yep, it is. So I just want to touch on public comment a little bit for the Citizens Advisory Board meetings, and kind of provide some best practices for that. The best practice is to have whoever's going to be speaking and giving public comment to come to the front of the room. That gives you a little bit more control over it as the chair, because then you're not having people shouting questions or shouting things out from the audience. You don't want to get into a situation where you're doing that. Depending on how that works, that could end up being an open meeting law violation. So you'll want to have them come up to the front of the room. Generally, it's best that they address the board, not whoever is presenting. With questions and whatnot, they can certainly. A lot of times, people in public comment ask questions. You'll notice at Planning Commission and Board of County Commissioners, most of the time, staff doesn't directly address those questions. That's generally a good practice. So a lot of times what will end up happening is, I was at a CAB meeting this last week. We answered all the questions after everybody had finished talking. We addressed that with the permission of the board, but generally we're not going to address questions at the end of each public, at the end of somebody's public comment period. We'll wait until later. It's not good practice to be having that open dialogue. That can be an open meeting law violation, because then you could be deliberating between the presenter or the board and whoever is presenting public comment. So you want to stay away from that. So really, those are just a couple of points that I wanted to make. It's best to not do that. If you are going to answer questions, do it at the end. Answer all the questions. Make sure that everyone's questions are heard. You can't pick and choose whose questions you answer and whose you don't. Staff is not going to participate in question and answer unless it's at the end. We're not going to put staff in a situation where there's potential open meeting law violation. Similarly, if they're doing a presentation and people are shouting questions in the middle of it, they're going to stop their presentation and leave, again, because they're not going to be put in a situation where they're going to be potentially violating open meeting law. So I just want to make that point.
Sure.
This might go over to Steve, I'm not sure, but most of our boards are odd numbered. So if we have somebody that steps out for conflict of interest, and now we have an even numbered board, and they vote 2-2 split, let's say for our board, does that just nullify the vote?
So because you're advisory, and we just had this come up recently, because you're an advisory board, it represents a no action.
No action.
So no recommendation gets sent to the Board of County Commissioners. And I also want to point out that if a Citizens Advisory Board votes to table an item, especially if it's a planning item specifically, because planning items have a specific time limitation set in NRS, that item is not going to come back to the Citizens Advisory Board. It will continue on to the Planning Commission and to the Board of County Commissioners, unless the applicant voluntarily waives their right on the time limit there. Generally, they're probably not going to do that with the Planning Commission. With the advisory boards. They may with the Planning Commission, but they are not required to. So just keep that in mind. That if it's a no action, it's not going to come back, and if it gets tabled, it's not going to come back to the advisory board. And generally with the Planning Commission too, same thing. I know there's a couple of planning commissioners here. With the Planning Commission, it's the same thing unless they're the the final decision-making body on that. If they're the final decision-making body, then, and the applicant is willing to table it, then that can happen and it can come back. But the applicant still has to be willing to table it, unless that the next meeting will be held within the 60-day time period. Did I cover that pretty?
Yeah, the only thing I'd add on the planning commission per county code, if it's a tie vote, it's a denial, deemed a denial if they're the final decision maker.
Yeah, and same with the Board of County Commissioners, if for whatever reason it's a tie vote and they're the final, well, they would be the final decision maker on that, then it would be seen as a denial.
I just wanted to go back to on the public participation part. If you open it up, everyone gets 1 round of 3 minutes. They are not to speak to like the developers. They're not to speak to anyone within the public. They're supposed to address their concerns to the board. If someone they sit down and they're like, oh man, I forgot to say something. I want to get up and say something. If you allow them to get up during that time, then you have to also then allow everyone else to get up during that time and repeat the process. So you have to be very picky on and choose what you want to do. Staff's recommendation always is, if they have something else to say, please put it in writing and send it to us. And then that way it will eliminate your concern of having to monitoring and keep doing that. And also if it's really important to them, they'll do it. If it's not, they won't. So I just put it back on them, say, if you have more comment, please email it to us or put it into some sort of letter form or have them send it in to us either way.
That's an excellent point.
Yeah, we work together pretty well. And it just goes to show like how complex this really is. I mean, there's like how Steve says, it depends on the situation. It truly always depends on the situation. And so that's why we always try to make sure that we're always working together. So,
Erin?
yeah.
I had a question on the public stating their name, and I know I asked this in an email, but
Sure.
so at our last advisory board meeting, somebody identified themselves with their first name and the street they lived on. So that's what was put in the minutes.
You can.
Or if somebody doesn't want to state their name, you just put anonymous. I mean,
Yeah.
if somebody doesn't want to state their name, you still take their comment, correct?
Yeah, you'd still.
Or their public input.
Yes, you're
Okay.
correct. And going back to your putting someone's address on there. Yeah, or street name, however you want to put it. You can put that within the minutes. It kind of depends on how much you want to elaborate on that. If you were to, yeah, my point being is that technically you don't have to put the residence in there. If you're yeah, but you can just like go in and get the substance of their comment. Is their comment about their street? Then you don't necessarily have to put it on there, right? Yeah, interesting point, but yeah. Okay, so you went through your meeting. The chair did a great job of making sure that everyone who was here was heard, everyone's voices were heard, and they conducted the meeting really well. So now we're going to draft your meeting minutes. What I do is I take everything that's on the agenda, and I didn't have enough picture space to show you the entire agenda. But say, as you look at 1 is 1 on your minutes, 2 is 2. You want to put in there the copy and paste that exactly. Because if you have to go back and refer to your agenda and then have to go back to your minutes, we want to make sure that we're having an accurate document. So everything that's on the agenda, minus the extra information on public participation, but anything that's like an action item, like for review and adoption of the agenda, copied and pasted and complete. Then after you have copied and pasted and you started your template, everything in there, you're going to start drafting everything. What our practice is in Lyon County is that we want to have our draft minutes started, and it helps the secretary in 2 ways. One, by the time you're done with your meeting minutes, you want to be 90% done by the time you get out of your meeting. So you're not spending the next day of your life reliving that meeting and listening to the audio. It's horrible. If anyone's had to do that after a period of lifetime, it is time consuming and it's not a great experience. So if you can capture as much as you can during the meeting, you don't have to relive everything the next day. Also helps because the secretary or the clerk of the board can then say, when they're going through their minutes, and they can it's basically like a check off list. Did we capture this? Did we capture this? Did we capture this? And so it helps, it's like almost like a checklist. And it keeps your meeting, like the motion of your meeting going, and you can help keep things on order with that. So as I put on 1 for the meeting minutes, we called to order. We want to make sure that we have the time that the meeting was called to order on there. That's why it's marked in red. There's a requirement that when someone is present, we want them noted that they're present, or if they were absent, and if they were excused or not excused. If they're attending by via Zoom or telecommunications. And this is more important, I think, on the side for boards or committees that pay for people like travel reimbursement. So it actually helps on that case too, that if you know someone, because sometimes people forget, or if you have to go in and you have to do those travel reimbursements so that you know that that person was there or not there. But it's a clear record for the court too. As much information you can give to a court document, because this is considered a legal document, is better. So we want to make sure that we're putting in who's there, who is not there, and if they're excused or not. And public participation. So when we get down to start typing that in. I know that with the advisory boards, you may not be able to have that capacity because you're actually more so participating in the meeting. You may be doing your meeting. I understand that may be harder for you on the advisory board, but other boards like commission, if you have a designated secretary, it's great to have.
So my first question would be, can we get recorders where I can stop it and I don't have to listen to the entire meeting 2 or 3 times to get the minutes noted? And then the other thing is if this is a legal document, I should not leave anything out that our public actually says.
So when I say legal document, I'm not saying it's a legal transcription. That's totally
Different things. But on the other side of that, if this paperwork is used by the Attorney General's office, shouldn't it say what is noted in
So
the recording?
The Attorney General has stated that your minutes does not have to be verbatim.
Okay,
So they gave you the outline of what their requirements are. So as long as you're following their requirements, that's what they're asking for.
all right. And then as far as the recording, is it possible to get other than on our Google? Because some of us don't always have Wi-Fi access. Like I go home, I listen to the recording and I'm typing through and I'll miss part of the sentence and I'll go back and
Are you
What
listening
were
to
they-
it off the device, the recording device itself?
yeah.
Oh.
Yeah,
So
and
you
there's no way to
put it into
actually
a
stop
music
ours.
file and like have it transfer it to your computer, like save it.
And not unless I actually download it to my computer, can I save it? Because I don't have Wi-Fi at home.
Yeah. That we can talk more about that later.
Okay.
First, please. We get public written, somebody will send us correspondence and ask us to present that. Do we read that into the public comment section?
If you do not provide copies for everyone, yes.
Okay, and then does that part you?
So that should be made part of your backup information. So depending on if it is just part of your board meeting, but say if it's correspondence for a planning item that you're transferring with your your letter of transmittal, then yes. So if you're submitting it, it should be submitted with it at the same time. So if you gather public participation for say a planning item, then yes, all that would be come together and we need to forward that to the planning commission and then the board of county commissioners. Okay, so on our little mock-up agenda, we get to the point to public participation, and Cindy Smith reported there is a speeding between Yerington and Wilson Canyon. So if we documented that, and so that's why I put it in red. And so I want you to think about for a minute, is this something that would be important to transfer to either county staff or to the commissioners for report? So in your minutes, it doesn't really give you a whole lot of description in there, but we're capturing the gist of what our requirements are, but it's not giving us a whole lot of information. So think about that for a minute. If you read that the way that it is, or if, say Cindy Smith came up in her meeting and she said something like, you know, since they closed the canyon over in Wilson Canyon, I'm seeing a lot of speeding. And I've noticed that there's possibility for a lot of traffic accidents and accidents that could occur. And I want the sheriff to be notified. So that's two totally different things. So we have to make sure that we're capturing it in our meeting minutes, which we did. We captured what she said and the gist of it. But if it's important enough, is that supposed to be made part of a letter of transmittal that we need to be reporting or an email report? So that was just one piece that I want you to hold on to, and I'll show you what I would do with it when we get to the letter of transmittal part. So we get to part 5, for possible action, review and adoption of the agenda. John Smith moved to approve the agenda as presented, and Cindy Smith seconded. The motion passed 5-0. So as we were talking about earlier, we want to make sure that we're getting who John Smith is for the record, that he's the one that moved it. Cindy Smith is the one that seconded it, and the motion passed. So those are the 3 things that we need to make sure that when we're capturing a motion, all that's the basic contents that we need to make sure that is transferred over onto our meeting minutes. So we get to item number 6. On there. Oh, I think that may be different. Oh yeah, that is 6. Sorry, it's hard for me to read from over here. So we have Harry Jones moved to appoint John Smith as the board chairman, Cindy Smith as vice chairman, and Harry Jones as secretary for 2023. Cindy Smith seconded. The motion passed 4-1. Jane Doe opposed. So why is putting what the motion was there important? Because if we just put 4-1, we don't know who that opposing person was. So we need to make sure that either you put who was for it or against it. Usually whoever is against it is usually the minority, but you want to make sure that you have it clearly documented. So if you went back, you know who the 4 people are. Jane Doe is the one that opposed it. So if you have an opposition to something, that has to be documented. You can't just leave it 4-1 and not anything after that, because who did it? That doesn't make sense. Or wouldn't make sense if you as a public came back to read it, what actually happened. So while we're in charge of keeping your minutes and your audio and everything, we keep it for 5 years. I know within the NRS, they say 3 to 5. I think to me, it makes sense. I keep everything for 5 years, because if I ever have to go back to the minutes within 5 years, I want to know what was on the audio in the last 5 years. So in our office, we keep everything for 5 years. When we look at our minutes, we need to make sure that the date and time and address of the meetings there, the members in attendance, we went over that. State the substance of all matters discussed, reflect each member's issues and concerns on any matter, reflect each member's vote on any matter, and the substance of the remarks made by the member and the general public. Minutes should reflect what happened in the meeting, so the flow. So if you open it up for public participation, where was that public participation? When the motion was made, where was the motion made? So you should have a general flow when you read the minutes, what happened at your meeting. So when you go to check your minutes, please verify that everything that is in red on the very top, where it says the Smith Valley, I just put the advisory board up there, that all these requirements are met, that stuff is captured on your minutes. So review to make sure that you're being compliant with what's required for your meeting minutes. So as we were talking about a little bit ago, Cindy Smith reported there's a speeding in Wilson Canyon. So we get to number 9 and we get to a zoning issue. And Jane, for possible action, we're going to forward a recommendation to the Board of County Commissioners for a zoning application. I didn't put all the information in there because there's not enough room. But there was a presentation and discussion, so we're going to put that in there. You're going to want to write what the gist of whoever presented the item, what the gist of the discussion was. If there was public participation or not. If there's not, include that there was not public participation. And then we want to get to the point of the motion. So Jane Doe moved to forward a recommendation of denial to the BOCC. John Smith seconded it, and the motion passed 2-0. That doesn't quite make sense here, but it should have been 5-0. So we want to make sure that we're capturing everything correctly over onto the minutes. So if you have something like this and it says 2-0 and you're the chair and you're reading this, you need to go back to your secretary and say, hey, before we publish these for final approval, we need to make sure that this is true and correct. Why does it say 2-0? So that's the other part, is if when we're working on the board, that we need to make sure that whatever we're putting across to people or for our board to review, the chair is a final person who verifies and corrects anything that needs to be done on the board before you put it onto the agenda, if you can get it there. So with those two things, I wanted to kind of highlight on item number 3 and 4, what now as the advisory board would you do with these 2 minutes? So as a secretary, you drafted your minutes and now you have these 2 items. So either the chair could get a hold of the secretary and say, hey, I think we need to add some more information and send off a report for number 3. And, we also need to send off more of a report for, obviously, for number 9, because it's a planning item. Let me go this way first. Okay, so on item number 3. So when you look at just the very clear and concise way that you would put someone there for public participation, doesn't always capture enough detail that we would send over to the board or someone within staff. So if you have, this is what the letter of transmittal or reports are for. It's to give us a clearer picture or a more detailed picture of the item and what you as the advisory board want to do with it. So this is more of a verbatim statement of what she said. It's not verbatim, but it's more of a better synopsis of what she said and what I need to get across my point better across, because if you did this for every single item on your agenda, you'd be there all day long. So that's why we created the reports. So what is it that you want us to do with the information? See if the sheriff can patrol the area. The advisory board's concern is the increased risk of traffic accidents. And on the zoning map amendment, same thing. It's going to tell us when you met, what the item's for, where you want it to go, but also what's very important, and I think may not always be clear, is we need to understand if you're recommending denial or if you're recommending approval. I know that it's not written on the agenda item because you can't predispose which way the board's going to move, but make sure that you add in here if your board is in support of or not in support of this item and why. The why is a very important part. It's a secondary part to the first part of that. You recommended it or you didn't, but why? What's the substance of why? And my recommendation is if the planning commission and the board of county commissioners has to look at the conditions and they have to look at the staff report. What are you basing your decisions if it's not off of that? So I know that traffic is always a concern for all of us. We don't want high traffic in our area, right? But can we deny someone if NDOT cannot deny them? Can we deny someone if, say, the Stagecoach GID is going to give them water? Water is a concern, yes. But if GID says that, what other legitimate thing can you tell the commissioners that's within that staff report of those conditions that you can see that you could give a recommendation of or insight of that you may think that may be of importance? So I would look there first. And if you're making a recommendation off that, we ask the planning commissioners or the Board of County Commissioners, if you're going to deny something, what is it based off of? So I would challenge you to do the same thing, other than just doesn't fit for our community, which is totally understandable from a community standpoint. But as advisory board members, push yourselves to get into further into that game. What can you give the commissioners so that they can understand where you're coming from, but at a higher level so that they can help you get to where you want to be and understand where you're coming from. Also, I just wanted to point out that we do get several applications in a year. The commissioners, the planning commissioners and the Board of County Commissioners, they don't see all the applications. If they don't meet the requirements for their application to be pushed forward, you don't see them. And I don't know how Andrew puts a big old stamper of denied and mails it back to them in the mail, I'm not sure. But if we can't find a reason to give them a fair handshake and to have that public hearing, and I think that's what everyone should understand of this concept. If we can't give them a fair handshake to understand if this or to move forward with their application, what are we doing? That's not quite fair because they have rights too, right? So how can you objectively see their application, objectively see why this will not work within your community, other than we don't like it? Andrew, do you have anything else you wanted to add to that? Okay, I'll be quiet. So as soon as you get your letter of transmittal together, we want to hear what the public stated. You could do this two ways. You could say, Erin said this, Stacy said that, Andrew said that as part of the public. Or you can get just a synopsis. The public's concerns were the right-of-way passage, the easement, something, or sometimes they say the street light, or there's too much traffic, or school. But you can also do a listing of they have these concerns and why. You don't have to list every single person that talks. You can do it in a summary, but make sure that you get everyone's voice on that summary. You can also do that the same as the chair concerns or the board's concerns. You can do it from each board member, or you can do it as a summary. The board's concerns were these. So you can shorten it a little bit. If your report is going to be very long, you can use this as like a letter, what are those fact sheets called? Like your front page. Oh, is it? You can do it as your cover page, and then you can just attach more paper to it if you want to, if that works better. So there's a couple ways you could do something. Try not to kill yourselves. If you have questions, reach out to me. I'll try to help you as best I can.
So Erin?
Yeah.
So you had two separate things on this transmittal letter. Would you do two separate ones or put them in one?
I would do it two separate
Okay.
because they're two totally different things. This one's going to the Planning Commission and the Board of County Commissioners. The other one would probably go to the Board of County Commissioners, but we also maybe send that off to, they're not totally related. So I would make two different ones. I'm gonna give you the Steve answer, maybe. Oh, is that one dying? Wow. Be funny. Okay. So just depending on the circumstances, but I think it's if you have two totally different topics, it's easier just to send two. Okay. So after your meeting, you have your drafted minutes, you have your drafted letter transmittals ready to be sent out. You send them to your chair first, have him review everything, you get his consent to move forward. And then you send whatever was final approved. So on that meeting, what was your final minutes? You send those to the clerks, the county clerk's email, and then we'll get those posted for you. Your final minutes, I'll save and then I'll post to the website and I'll send you an email back confirming that I did that. Both letters of transmittals, you can send in the same email, it's fine too. But staff will make sure that that gets sent out to or added to wherever it needs to go. And your agenda, your final minutes needs to make sure that it's saved in your Google Drive with your audio every single time, every single month, because we know how electronic devices work. Sometimes they work, sometimes they don't. So do that every month. And then you guys did really great. Your guys' meeting's done. And now you get to start all over again. So that's how the whole meeting process works. So canceling a meeting. So you're going to go have, you're planning on having a meeting, but then you get a couple of responses that some board members aren't going to be there. So you know you're not going to have a quorum present. So this is a little mock-up right here of the agenda. This is all you need. I don't need the ADA. I don't need everything else. I just need a notice of cancellation so that I can post it on the website and I can electronically send it out to people who have signed up for it. So you send that in like you would normally send your agenda. Just our meeting is canceled. Can you please post this for us? And I'll say, sure, great, we'll do that. And you send that to the county clerk's email. Sure.
Would you send that, then post that at your meeting location also? So because some people may not get those notifications, they didn't sign up for them. But you show up for the meeting and it's not there. So should that be posted? We have a bulletin box
Yes, I
outside
would
where we
post it
do it.
there.
That should be put.
Yeah.
It'd be a preference.
So if
Okay.
it's in time to, so if you have time to go down there and post it, we want that notification posted on the building. If it is posted right at the time, we ask that someone stay back from your board to just stand at the door to make sure. So if people start arriving, then you can tell them, because you may not have a printer available at that time.
When you send out the notices. Sorry. So if someone asks for those electronic notices, can you send them the link or do you have to send them the agenda and all the backup like in a separate attachment? You can't, can you just, I mean, do they just get the link to the website or you have to send them the actual agenda if they request the agenda?
I send them both because I
Both?
think it's good for people for two reasons. One, they know where to find it in the future. And then I just send them a paper copy because then that also, it's considered a public records request. So if they're asking for a public record, you want to make sure you give them if they ask for electronic, you send them the PDF file. Then I show them, I just give them a little informational, hey, this is where you can find it in the future. If you would like to sign up for our agenda notifications, this is how you do it. And then every time that there's an agenda, it will go to your inbox. Every time it's canceled, you'll be notified. And I have to date maybe 3 people that still get the agendas. Everyone else would rather have their mail through the email than through the post office anyways.
Erin, a quick follow-up. I'm red. Okay. To that, if someone requests the minutes in audio form, do you send them just a link or do you also send them the audio file itself?
So if they will accept the link to it, the thing you want to be careful about with the link in your Google Drive is if you send that to them, then they have access to your entire Google Drive. Because then you could be sharing it that way. So what I would do is I would download it either into like a public file out of your Google Drive and send that to them so that they have just access to your public drive, or I would just download it and send them that file.
Okay. Do we know what the NRS requirements are? If someone says, I want the audio file, do you have to send it to them?
Well, it's like I said, if they will accept it.
Let's say they don't. Let's say they
don't,
want the
then-
audio file. Do you
So
have
if
to give it to them?
if they tell you that they want it on a thumb drive, then you will refer them to me and I'll take care of it for you. Does that make sense? Because then you're not going to incur those costs of getting it to on a thumb drive. But I'll say 9 times out of 10, people just want the file that they can download. But if they wanted it, say, on a different device, then I will take care of that for you.
State law says that we have to provide it on a piece of paper. So.
District Attorney Rye, what is reasonable?
Yeah, that question came up earlier, I think, too. So that it is specific to open meeting law. If they request a copy of the agenda, they're entitled to get that. The county can send it via email. And that satisfies the requirement. But if they ask regular mail and don't want to accept it via email, they don't have email, we have to send it regular mail. They can also agree to accept a link in lieu of that, as Erin said. And you can send the link to the website. But just telling them it's on the website is not sufficient. With the recording, the county has to provide a copy of the recording free of charge under the open meeting law, different than the public records request. But the open meeting law does require that a copy of the recording be provided free of charge.
Okay, so a link is not sufficient. If a citizen says a link is not sufficient, I want the recording, it has to be provided.
That's
you.
my understanding, and I think that's what Erin does for the.
Okay, thank you.
Okay, so next meeting cancellation is if you show up and you don't have a quorum. So if you look at your agenda, when you get to number 2 and you get to the roll call and you're going through everything in your meeting, or excuse me, let me back up. So you get there and there's not a quorum. So what do? You're going to start your meeting like you would anyways, because we need to have a record that it was canceled and why. So that if the AG or someone were to come back and they said, hey, Erin, I'll just pick on Stagecoach. The Stagecoach Advisory Board had a meeting last night and I showed up and no one was there. And I showed up like 15 minutes later. What happened? So I have to have a reasonable way to communicate to them. And how would I do that? So what we want you to do is start your meeting. You'll start the recording and you'll go through it like, 1 to 2, and you'll read into the record, the date, the time, the location and everything. And then when you get to 2, you're going to say who was present, who was not present. There's not a quorum. Therefore, this meeting will be canceled. And that's it. That's all you have to record. And then you're on your meeting minutes. That's all that you're going to put on like that piece of paper. And you can submit that for approval to your next meeting. Why? Because 1, you can share the recording with your board members and then they can approve those minutes because they listened to the audio. And 2, they will know if they were there or not. So we need to keep an accurate record. And then I post that. And then I know that the reason why your meeting was canceled and that if anyone should have any questions, we can supply that information to them. And we have an accurate record. So if that should happen. So likely this will be because oh, that's not the right one. So if you posted your agenda, so this meeting cancellation is if you posted your agenda and you now know that someone then calls in sick and then someone else can't show up, we're going to basically not amend your agenda, but we're going to then send out this notification. So it's going to be the same agenda, same date, time, and location, but you're going to just put canceled. This regular meeting has been canceled and our next meeting will be on March 5th or whatever your next meeting date will be. So there's the first cancellation to where you know that no one's going to show up and you don't even put out an agenda. The second one is you posted your agenda and then you found out that no one's going to be there or that you won't have enough for a quorum. So that's the first 2 agenda notifications or cancellation notice that we'll send out to people.
The thing that almost happened to us at Dayton this week. I'm not sure how that would be handled with notifications like this. What happened was we went to start our Zoom and all we got was, we tried to log in as a notification on the screen that said, your software is out of date, contact your IT administrator. And it wouldn't let us start the Zoom. And so fortunately, 2 minutes to 7, one of us got a workaround going and we were able to handle or start the meeting. But excuse me, what if that hadn't happened? We would have to cancel the meeting, but put something on the door, I guess, is a possibility. And then what kind of notice do we need to send in like
so
this?
if it's like at the meeting, If you're at the meeting and you realize that your Zoom information is not true and correct, and you have feeling like that the open part of that has been compromised, then you cancel your meeting. I would still start your record recording. And I would still state for the record the date, time, and then I would get to the part after you do your attendance, why you're canceling your meeting, and it's because of this reason, because of Zoom.
But see, we couldn't even start Zoom to do the recording.
Right, but you still have an audio recording of who was there, the occurrence, and what happened, and why you canceled your meeting. And then you can still reflect that in your minutes, so that if people come back and they read what happened at that meeting, then they can see that you canceled your meeting because they couldn't log in and they didn't know why they couldn't log in. So now you have a record of why you canceled it.
Yeah, I think we're using just Zoom for our recordings at Dayton, so.
Oh, I see what you're saying. So
Yeah.
then at that point in time, you could grab someone's cell phone if you could, but if not, then at least have your minutes, transcription recording, if that's minimally what you could do.
Okay.
Yeah.
Yeah, might need to.
What's the definition of an excused and non-excused absence? Who determines that?
So say I have some personal engagements and I didn't tell the chair, and I chose not to tell the chair that I wasn't going to be there, or a representative, usually it's the chair, that would be unexcused. If you are sick and you say, or you come up and you say, my kids have a baseball game and I don't want to miss it, and the chair will say that they called in and that they're excused. What you don't want to do is join a board and then not show up. So if you realize that all these meetings are going to be for every single baseball game that you have for the entire season, maybe then as a person, you're saying, maybe I'm not really quite well fit for this board if I can't show up. So technically, you just want to make sure that it's like missing work. Would you miss work for this excuse? So as long as the chair is notified and that there's a reasonable understanding of why that person can't be there. Does that answer that question? Okay.
There's no threshold in open meeting law anywhere in the states, and you miss so many meetings. You can find.
There's nothing, we can't ask you to resign, but we can remove you, because in the bylaws it says and at least in the Citizens Advisory Board, it says that we can remove you after 2 meetings, unexcused. Yes. So if someone has some health issues and they miss a couple meetings, we give them a little leeway, because we can't always predict what happens, but as long as they get back to it as soon as that they're available too. But it's just conscious, if you know that you're going to be out for an extended period of time, respectfully, you would think maybe I should resign my position. And then you just send in a letter of resignation, and you can choose to, tell the board why or why not you're not a good fit at the board for this time. That always goes a long way than just not showing up. Because that puts other pressure on the rest of your board members to take care of that situation. Gina, can you unmute yourself?
Yes.
What was your question?
Oh, it was already answered. It was that we were doing the recordings. Our audio recording was through Zoom as well. So it was already answered.
Okay. All right. So we got through the first meeting cancellation. The second one is after you posted your agenda. I still need you to send one in, because I need to notify the people that your meeting has now been canceled. And this is literally all I need for a meeting notification. Just what's in this little box right here. It doesn't have to be really extravagant, just the gist of this information. And so we kind of touched on that. If there's not a quorum at the meeting, we need to make sure that we start the meeting recording, go through the steps, make sure that we capture what we need to and why that meeting was canceled. And then also make sure that you have someone standing outside for at least 15 to 20 minutes to make sure that you can tell someone that you're not going to be there, and minimally, or if you can get to a copy machine, you can put the posting on there, but that's probably not likely in your circumstance that you'll be able to get to a computer and printer. I mean, you could write it on a piece of paper if you wanted to, and stick that up on the door too. We always think of things, overthink things sometimes too. So just make sure you go through the roll call and you state everything, and you send in your minutes to reflect that. And that's the 3 different types of meeting cancellations. So the Board of County Commissioners, who are they in their websites? So I just wanted to make sure that you had their emails available for you. If you want to reach out to them, if you have any questions or if you need some guidance from them, they're a great resource for you to collaborate with. The Board of County Commissioners is 5 members. The Planning Commission is 7. If you didn't already know that, we can give you some of the Planning Commissioners emails if you guys would like those too. But the majority of your collaboration will probably be with the Board of County Commissioners. And they're basically the Citizen Advisory Board's bosses. I just wanted to provide a couple of websites for you. We go over so much information, it gets kind of convoluted and there's so many different caveats of how things work and how everything rotates together. But this is the gist of the information where we find everything that helps us to get you guys up and moving on your boards. So if you have any questions where to find something, that's a great place to look, or you can ask one of us to help you. And if I didn't confuse you enough, let me answer your questions. No questions. I'm not as popular as Steve.
Erin,
Oh, go ahead.
of course I have one. Going back to I had been writing my questions down, the 2-week staff notification for attending a meeting. So if we want to have the roads department attend a meeting, will we send that directly to the roads department or to you or to, the county clerks, or to you or to both?
I would send it to the county clerks and then also to whoever you're sending it to.
Like the
because-
road, if it'd be the roads department, okay, so.
Yeah.
Yeah, that's what I meant. Yeah, the director of the roads department and county clerks is who we would send it to if we have a request for something like that, or
Yeah.
whatever department it is.
Yeah, that way
Okay.
we can kind of help monitor things and make sure that if we can't help you or find someone else, a different resource for you or whatever, but we like to be included.
Okay, and then the advisory board reports, there's a transmittal letter that you send in. What exactly should be, if we do an advisory board report in person, what exactly should we be transmitting? What should be, is it a synopsis of the meeting? What exactly are they
So-
looking for?
Are you talking about like a live report to the board?
A live report in their meeting, yes,
Okay.
where they have that advisory board reports
So basically it'd be exactly the same context, except for.
as a transmittal letter?
Yeah, so
Okay.
you want to tell them what your motion was, why you made that motion and who spoke about it. So you want to give them, basically it's the same as the minutes,
Okay.
right? What was a summary? Who talked about it? Where'd you get?
Okay, I wasn't sure if it was something different. It's just a synopsis of the transmittal letter then. Okay, thank you.
Any other questions before I turn it over to Andrew on planning? Sure.
Does your agenda just follow to the next month automatically when you cancel your meeting? Or you got to submit another agenda? Because you can make changes into it if you want.
Well, you're gonna automatically have to change the date, the time.
Right. But it's,
The date.
I meant the body of it.
More than likely, you may add to it. But I would just copy and paste it to wherever, or save as to the next meeting and then just review it to make sure you don't have any additions or deletions. Okay.
We'll take a quick break.
All right, we're gonna go ahead and get to the last presentation. This is a little bit different topic, but it's something that I wanted to make sure that we covered today, because we get a lot of questions about planning and the planning department, and that's a lot of what community development projects. Excuse me, can't talk today. Are a lot of what each of the individual citizens advisory boards and the planning commission and the board of county commissioners talk about. So I wanted to provide an overview so that everybody kind of has a little better understanding of planning and the planning process and kind of how things work. Some of the feedback that we get is, well, staff's always recommending approval. Erin kind of touched on it a little bit. We're certainly not always recommending approval, but by the time the project gets to your boards, staff has kind of determined that they meet a lot of the different requirements that allow that project to move forward to the public process. And so I'll talk a little bit about that in this presentation. So one of the things I want to cover, master plan and land use designations, zoning, and how those two relate to each other, because they are very different. And I think people tend to not understand the relationship between the two. It's kind of complicated. So I will run through those, talk a little bit about what findings are and how we make determinations of whether we're recommending approval or denial on a project. A little bit about the public process, and then talk a little bit about development requirements. So to jump right into it, master plan designations provide a framework for future development in Lyon County. Every 10 years, we go through the master plan process to update the master plan. We try and get as much community involvement as we can. What a master plan designation really is what the community wants to look like in the future. Not necessarily what's there on the ground now, but how we want growth to take place. And so, as I said, it's based on input from the community, the elected officials, the appointed officials, staff. We go through this huge process. I think the last one took 3 years to complete. It's pretty significant. Master plan designations do not remove or vastly change ownership entitlements or to properties. So it doesn't change the underlying zoning. And I'll get into that a little bit on the next slide, but it doesn't change what somebody currently has the right to do with their property based on their zoning. It's more of a guiding document. And I'll provide a little bit more information, but master plan designations are advisory in nature. They serve to guide the community at a policy level and to guide future development decisions. So when we're talking about zoning, zone changes and what that should look like, the master plan is the guiding document to that. We don't approve zone changes without it being conforming to the master plan. And then zoning is regulatory in nature. So while master plans are not necessarily regulatory in nature and don't give you any rights based on that master plan designation, the zoning does. The zoning generally servicing to implement the master plan and specify permitted uses, allowed densities and development standards. So there is a pretty major difference between the two. Zoning is a set of laws or regulations that govern how property can and cannot be used in specific geographic locations. It's really what you have the right to do with your property. So if you've got a single family residential zoning on your property, that gives you the right to have that single family residence based on the performance standards that we have in Title 15. You can see you could have a single family residential zoning, but a commercial master plan designation. The master plan designation does not give you the right to have a commercial entity on that property. But if you were to go for a zone change, it would, that would be compliant with, say, if you were to do a zone change from residential to commercial, and you were to put in that application, if it's compliant with the master plan, it has much more, it would have to comply with that master plan designation to do that zone change. Sorry, I'm kind of stumbling through that. But, the county cannot change zoning on a property without permission of the owner. So again, if we have that master plan designation, we say the community wants to see this as a commercial zoning district, community commercial, let's just say. The county can't go in and change that zoning unless the property owner requests us to make that zoning change. Just because the master plan says commercial doesn't mean that that takes away that person's right to have that residence on that property. And that's something that's really important to understand. That's how, as I mentioned, the zoning is regulatory and the master plan is advisory. But I'll get into a little bit in a second about findings, but you'll see how those two are related. So if we were to go in and try to change somebody's zoning without the permission of the property owner, that would represent a taking because that's somebody's property right. So we can't change somebody's property right without their consent. The US Constitution would prohibit that. So for a property owner to change their zoning, I already covered this, but the new proposed zoning must be compatible with that master plan and the legal findings that we have laid out in Title 15. So we get a lot of questions about, well, why is staff recommending approval on something? The community doesn't want it. Well, state law is very development friendly. And so because it's set up that way, and because of the way that we have our development code, I guess, set up, we have these specific findings that have to be made in order for a project to get recommended for approval or denial. If the project meets the findings, we recommend approval on it because that's in code, that's saying that it's laying out the design standards for how that project should look and what are the determining factors for why that project should move forward or not move forward. Findings are a set list of required conditions that must be met for a project to receive approval. So for example, the findings for a zoning map amendment, a zone change, are listed below. This is straight from Title 15. So it says, when approving a zoning text or map amendment, the commission and the board must make the following findings supported by a statement of evidence, facts, and conclusions. And then it has these three findings. And it says, so A, there is the proposed amendment is consistent with the policies embodied in the adopted master plan and the underlying land use designation contained in the land use plan. So as I touched on before, if somebody's trying to do a zone change and it doesn't comply with the master plan, automatically we would be recommending denial. The board can't really approve it based on these findings because it doesn't meet what is in the master plan. It doesn't meet that first finding. B is that the proposed amendment will not be inconsistent with the adequate public facilities policies contained in this title, this title being Title 15. Yes, sir.
You mentioned the land use plan. Where is that found?
The land use plan is the maps, the master plan designation maps and the master plan.
Synonymous with the master plan.
Correct.
Thank you.
Yeah, well, there's a set of maps. There's one for each community in the master plan and then one for the county, like as a general, for stuff that falls outside of the community. Those master plan designations, again, depict what can be placed in that area if you were to do a zone change. So each master plan designation has like several different zoning districts that could fall within that. So for example, one of the master plan designations that is pretty prominent here in Silver Springs is employment. So within the employment master plan designation, you could change the zoning to employment mixed use or light industrial or heavy industrial or one of those, but it has to be something that falls within that employment land use designation. There's a table in chapter 3 of the master plan that delineates which zoning districts can be implemented in each land use designation. So another question.
So you mentioned that the master plan is advisory. And it sounds like it's a little bit of a filter or triage of, if it doesn't meet the master plan, then it's not going to move forward, basically. But if a property owner wants to push that, can they?
So the question was if a property owner wants to push it, if it say it doesn't meet the master plan designation, if they wanted to push a zone change, can they? So they can demand that the application be heard before the planning commission and before the board of county commissioners. It would get turned down. Legally, we couldn't approve that based on that. Now that what they can do is ask for a master plan amendment. There's a process for that. And we do that. There's a whole set of findings that have to go with a master plan amendment. We only do master plan amendments 3 times a year in Lyon County. That's by state law, actually. So they're not too common, but it does happen. You do get folks that ask for.
Would that be the instance for like a special use permit?
No.
Or is that, what instance do they use the special? Oh, sorry. Is that loud enough for the special use permit?
Conditional use permits are a little bit different. Some zoning districts have uses that are allowed by right. And then they have uses that are allowed by a conditional use permit. Conditional use permits can't be used to allow a use that's not allowed in a zoning district where it's not allowed. Now that can happen if, say, there was changes made to the zoning district. So let's just say in the past it was allowed in that zoning district conditionally. We have some conditional use permits that are operating under that, but.
Yeah.
I had one, just what, and where I'm seeing it is like for like businesses, running a private business out of your home or something. Is that like, because when we get the applications or whatever, we go over with Carrie, and if it's not zoned in that area, can they get, is the avenue to get like a special use permit
So no,
for
so
running a business like that, or?
so a conditional use permit, as I said, you can't use a conditional use permit to allow a use that's not allowed in that zoning district.
Oh, okay.
So we, specific to your question, I mean, that's why your department forwards all that stuff to us and we review it to make sure that, us being community development, to make sure that it's compliant with the zoning district. There's a table in chapter, well, there's 4 tables in chapter 15 or title 15, chapter 320, that outline which uses are allowed in which zoning districts. So it's a little bit different.
So just to kind of play out the master plan scenario, and maybe I'm just hung up on the word advisory, so you and the DA can slap me upside the head if I am. But if, again, like you said, so a property owner says, no, I'm going to force this. So they're going to take it to either the planning commission or the board of commissioners. And then you said that the planning and or board of commissioners would they be obligated to deny that?
Yes.
Okay, so
if I can point something out real quick. So this is the section from the code. I didn't cite the actual, but this is actually directly copy and pasted from the code. And it says, when approving a zoning text or a map amendment, the commission and the board must make the following findings supported by a statement of evidence, facts, or conclusions. So if they can't make those findings, then the board can't approve it. Does that make sense? So so right there, right off the bat, say for a zone change, if it doesn't comply with the master plan, then they don't meet that first finding.
right, it just, that sounds more stronger than the word advise.
Right, but
so anyway,
and I'm using the word advisory kind of in the sense that it's not regulatory and that it doesn't provide you any rights.
But we would be, if the planning commission voted for something, we would be in violation of this language here.
Yes, correct. Staff would always recommend denial if it doesn't meet the planning or the findings. Most of the time, you don't see those projects. I mean, for every project that comes before an advisory board or the planning commission or the board of county commissioners, there's probably 10 to 15 other projects that didn't.
But actually,
maybe
if,
more.
if the property owner forces it, does it go to the planning commission or to go straight to the board of county
No,
commissioners?
it would go through the normal process. And so, yeah, staff would get up there, the presentation would be really quick. They don't meet finding A because, and we'd state the facts and, we would turn it over to the board. If the whichever board it was were to vote, say in favor of something that didn't meet the finding, then they would be in violation of the county code.
Yeah, and
Then-
let me follow up just briefly. The master plan is the governing document for development in the county. So anything you do has to comply with the master plan. When we say it's not set in stone, it can be changed through that process. And what the court says, it's not a straitjacket. You can change the master plan. But if it's not changed, like Andrew said, you can't do something that's not in compliance with the master plan.
So it's regulatory to that extent.
To that extent, it is regulatory. Yeah, it does limit what you can do, but it is changeable.
Yeah. All right, so.
Andrew, I just got a question because
yes,
it sounds pretty cut and dry what you were trying to say, which I kind of was hearing what Steve was saying. If the process should be, then a person should try to change the master plan before they try to adjust zoning.
Always, yeah, well, if it doesn't meet if the zoning that they're trying to go to doesn't meet the master plan, then yes, they would have to. And if
Change the plan.
Yeah.
Yeah, because if a small piece of agricultural land is no longer available for agriculture,
Mhm.
then that should be a consider, even though they have this little spot there for ag land. If it's no longer can be ag land, there's consideration of why you want that changed. And so that would be heard by the planning or by the commissioners.
Both,
Both.
typically, yeah. So typically goes to the advisory boards and the planning commission and the board of county commissioners. I do want to, that was kind of a specific to ag. There's some interesting things there. So I don't want to, that's a master plan designation. There's also now in Title 15 an ag designation, but there's residential uses that are allowed within that use too. So I want to make sure that I don't want to confuse the situation there too much, but yes.
So I guess having sat in on a lot of the planning and board of county commissioners meeting, it also seems like that the master plan is open to interpretation too with the findings. Because I think that's where a lot of the controversy comes from, because the way it's worded, it does seem like it's open.
So it depends on what you're talking about. So if you're talking about the land use designations.
No, the findings, I said.
Yes, but
Yeah.
the land use the finding here is specifically referring to the land use designations and then the policies. And so, yes, the policies are open to interpretation.
That's what I meant, yeah.
However, they're meant to be interpreted more broadly rather than more narrow. So.
Okay, I just wanted to bring that up. That
and-
seems like the big point of contention most of the time is the interpretation of it.
Sure, but I think that's even a statement that's made in the master plan, is that they're meant to be interpreted more broadly rather than more narrow. So people come back and say, well, it doesn't meet X, Y, Z. Well, yeah, I mean, if you interpret it very narrowly, then it maybe, but staff makes that determination based off of their experience and I mean, all of our professional planners are just that, professional planners. They do that for a living, so they go through that stuff. Oh, thank you. I have a feeling.
And Tom's not going to give up his.
Well, I'm sorry, what was the question again? Oh, okay, yeah.
So you mentioned master plan amendments.
Mhm.
Who can propose those amendments? And you said 3 times a year. So is there a timeline for that?
There is, we have a schedule on the planning website, on the county. You can also call and request it. We typically have a longer application period for that. There's some more review that goes into that with the staff. So it takes a little bit more time, but who can request that? So the property owner can certainly request that. Citizens can't really request to change somebody else's master plan designation. I don't think that happens. That happens when,
Okay.
you know, every 10 years we go through the whole process, but you can't just go and say, oh, well, I want to change so-and-so's master plan designation. You can't do that.
But the 10-year plan comes before the community,
Mhm.
and at that point, they can change.
At that point, there can be some changes that are made. Again, there's some conditions there that have to be made. I mean, it's a little more, it's not quite as, yes.
A little different.
I'm gonna take Steve's language here and say it depends. But in general, yes.
Sometimes the county will request it.
Yeah, that's a great point. So staff can request or the Board of County Commissioners can request a master plan amendment for something that makes sense. So that's generally we have at least one staff initiated master plan amendment per year. So
And
but
then-
something that's more broad. usually.
And Andrew, just a quick follow-up. What is the process for master plan amendment? Which bodies does that go through?
It would go before the advisory board, the planning commission, and the Board of County Commissioners. The Board of County Commissioners is the final say on that. Yeah, and again, there's a whole set of findings and things that have to be made for the for a master plan amendment too. It's not just it's not quite as subjective. Like we try to avoid like spot master plan designations. So let's just say it's all surrounded by employment and somebody wants one parcel in the middle to be residential. Generally, that's not going to conform with what we're trying to do there. So it gets pretty complex pretty quick. I mean, I don't know if anybody's ever like read through Title 15. It's got quite a few chapters, and it's you know, you can, we debate internally. I mean, which way things have to go. It gets pretty complicated pretty quick. But the main point is that a project's not going to get approved if it doesn't meet the findings. The second part of that, and I should have put another slide in here, is that if it's something where the actual development is going to take place, they have to meet the development standards too. Because a lot of times with a conditional use permit, there's a set of standards that go with that specific use. And so if it doesn't meet those design standards, staff's not going to recommend approval. And again, we see a lot of projects that don't meet those standards or wouldn't meet the findings. And, you know, we have conversations with them about it, usually in roundtable meetings. And we say, okay, your project doesn't meet approval. We certainly doesn't meet the standards, or it doesn't meet the findings. You're certainly welcome to take that forward if you want. We don't speak for the board, but if you do, just know that you're going into it with a recommendation of denial from the staff. 9 times out of 10, they decide not to continue with that application. We have one that's actually going to be moving forward here, that unless they change their standards between now and when it goes to the meeting, we'll be recommending denial. It's pretty rare, but it does happen. We've told them, everyone in my department has told them, look, you don't meet this standard, you don't meet that standard. And they've said, no, we still want to take our chances with the board. And we're like, okay, you can do that. But it's, you know, just know that staff's probably not going to be recommending approval on that. Yes, sir.
No, I just have a question. It seems like the last couple of projects come before our board, the flooding and drainage issue doesn't really get addressed in their, I don't know if you want to say the master plan, but
Well, I'll talk
in
yeah,
the
I'll talk a
development
little
of
bit
the
about-
project.
I'll talk a little bit about that in the presentation.
So should I hold on if I got a
yeah.
question after that?
Yeah, well,
All right, awesome. Thank you.
so that kind of covers the findings, and then the development, the development standards. So next, this example here, this slide here is specific to subdivisions, because that's the one that typically gets the most questions, I would say. So for project approvals for a subdivision, there's many steps that they have to do. So before the first shovel of dirt can be moved, a final subdivision map has to be recorded in order to split the larger parcel into smaller parcels. There are several steps that must happen before a final subdivision map can be recorded. So we already talked about it. If the project doesn't meet the master plan, then they're going to have to do a master plan amendment first. They have to do that before they can do the zone change if necessary. Now, if a subdivision meets both the zone change or meets the zoning designation already, even if it's not in compliant with the master plan, that project can still move forward with the tentative subdivision map. So I want to make that clear. If the zoning is already correct, the BOCC doesn't see the application before the tentative subdivision map. And they don't get a lot of say in the density, the lot size. You know, as I mentioned before, zoning is a property right. It's something that we can't take away. So if it's zoned for half-acre lots, let's just say, and, you know, it's 500 acres and it's zoned for half-acre lots, the board really can't tell them, no, we don't want half-acre lots on that size. Now, you can certainly ask. I know Commissioner Hendricks did in this last board meeting regarding project and Stagecoach that was 2-acre lots, and she had asked that some of them be 4-acre lots as kind of a buffer zone between some of the neighbors. And so the applicant voluntarily offered to do that. They didn't have to. They could have said, no, we want to stick with the 2-acre lots, but they, in general, most of the developers want to work with us. And so, and you know, sometimes that happens. Sometimes it doesn't. It can't be used as a reason to deny the project, though. And that's something that really needs to be considered. But again, you know, if they've got the zoning, it's really difficult to then turn down that project based on that. Now, if it doesn't meet one of the other criteria, one of the design standards, then, you know, that opens it up, you know, for some interpretation. The tentative subdivision map, for example, I mean, it has its own set of findings I didn't include here. You can find those in Title 15, but there's findings that have to be made there. Generally, those are related to the design standards and, you know, drainage being one of them, roads being one of them, water, all that stuff. There's the final process. So once the board approves the tentative map, right, that's telling the developer that, okay, the project is, at least in theory, viable, but they don't have to have all of the flooding studies done. They don't have to have all the road studies done necessarily. There's a lot of things that don't have to be completed. They don't have to have their geotech report done. Those don't have to be completed before the tentative map is approved. But all of those have to be completed before the final map gets approved. Now, the Board of County Commissioners does not, or the Planning Commission, they don't see the final map. It used to be that the board approved the final map. However, there was an ordinance that was passed so that the Community Development Director is the one that reviews all of that information along with their team, the county engineer. And once all of the design standards have been met on that, Community Development Director can sign that map. It's actually a physical map and it has wet signatures on it. Kind of cool if anytime somebody wants to check that, that's kind of neat. Community development keeps all track of all that. But anyway, community development won't and can't approve a final map unless it has all the other signatures on it. So if the county engineer doesn't sign off on it, no, we can't approve it. If they don't have their will serve letters from the utilities department or you know, whichever GID or whatever the case may be, if that's not signed off on that map physically, we can't approve that, and we won't. There's a whole number of things that actually have to be on there by law before things can move forward. NDEP has to sign off on it. There's other state agencies that have to sign off on it. If it's accessing the highway directly, then NDOT has to sign off on it. We get a lot of comments about people that about with regards to roads and highway access. Lyon County doesn't actually regulate highway access. The state does. So it's entirely up to the state on whether or not that project meets those standards. We don't really get a say in it. So as long as it's meeting state standards, then it can move forward. So all of this is to say that for a subdivision to move forward, it's quite a long and lengthy process. It's expensive for the developer. Just our fees for reviewing a tentative, or reviewing all the improvement plan, all that stuff. Usually, well, I don't know, from $50,000 to $100,000 just to have us review it. That's not to have an engineer that goes and puts that all together, design it, right? That they're responsible for that on their own. So, subdivision, they're well over $1 million before they even turn the first shovel. There's a lot of thought process that goes into it. And most of the time with a subdivision, they've been working in community for 6 months to a year, maybe more. And so the project that was just approved in Stagecoach, that's been ongoing, I think, since the early 2000s. So, well, in its last iteration, before that, since 2006, I think. So it's, and again, that might have been when it came to a public meeting, but staff starts to work with them, because a lot of times what happens is a developer will bring forth a plan and we say, nope, this doesn't meet our standard, that doesn't meet our standard, you're going to have to work on that. There's a whole lot of work that goes into it. So when you wonder why by the time it gets to a board meeting, we're recommending approval, it's because we worked through a lot of the issues. I will tell you, I'll kind of get into it here. Well, now's a good time, I think. I don't think I have a slide on it. No, yeah, I do. Okay. I don't want to go too long either. It's I talked about it a little bit, but tentative subdivision map, I probably should have, these slides got out of order a little bit, but it's a map made to show the design of a proposed subdivision and the existing conditions in and around it. Board of County Commissioners adds conditions to the tentative map and approves tentative maps. Conditions must be based on development standards and can't be capricious or arbitrary. We get in trouble if we try and add that stuff and the developer doesn't agree to it. And as I said before, if the zoning is correct and the developer's development standards can be met through the conditions placed on the map, it's pretty difficult for the board to deny a tentative map. It represents a taking of property rights. Now, you might wonder, well, what's the point of it even going before the board then? Well, there may be things that staff missed, right? There may be conditions on the ground that we didn't know about. I'll give you an example in a minute. I think the next slide not the next slide, but maybe the one after. So when we receive an application, this is the process that it has to go through. It's not exactly simple, right? And let me see here. You can look at to see where the advisory boards are. Okay, well, it doesn't matter. It's on this chart somewhere. But you can see it works its way all through this process. We only have 60 days for a development application to go from the start of the application period to a final decision by the Board of County Commissioners or the Planning Commission. So when I said earlier that the advisory boards, if they table it or if they don't come to a decision, it doesn't come back to them. That's because there's no way to meet that 60-day deadline if we were to do that. So it's really important to consider those applications as they come forward. We only have 3 days to deem the application complete. We have to issue them a letter stating that the application is complete or incomplete, and then it starts the process and it goes through all of this. We have to go through the advisory boards, we have to go through the Planning Commission, and then of course the Board of County Commissioners. There's also an appeal process. So if the let's just say the planning commission is the final say on something. And the applicant doesn't agree with the planning commission, what the planning commission says, and the applicant has the right to appeal that within, I think, 10 days to the Board of County Commissioners. And likewise, if the applicant doesn't like what the Board of County Commissioners says, then the applicant has the ability to appeal that. If all the project meets all the standards and meets code, and the board turns it down, it goes to judicial review, and then the judge says, okay, does it meet the standards, yes or no? And if it does, then the judge will overturn that. They can change the conditions that the board was going to place on it. So you might get fewer conditions, you might get more. It's kind of a gamble there. I mean, you could end up with more. Let's just say, originally the board had talked them down in number of units, number of lots, and it goes through judicial review. In theory, the judge could say, well, that condition no longer applies, and they could raise that number of units back up. It's a whole process that goes through. So that's why, when the planning commission and the board and the advisory boards talk about these items, need to be specific as to why, if they're recommending denial, or if they're in the case of the board, if they are going to deny a project, they really should be specific as to what standard they're not meeting and why. That'll help it out, because then, if it ever goes to judicial review, the judge can say, okay, well, the board thinks that they don't meet this standard because, XYZ, and, case closed.
So,
Yes.
Andrew, that was going to be one of my questions, is if in the recommendation for approval or denial, we should state according to the master plan, the reasons for recommendation or denial?
I mean, you can take a look at different standards. I mean, if it's something that meets the zoning, the master plan is really not going to apply too much unless there's a policy that specifically
Okay,
is
so
called out.
it's, okay,
So you really got to take a look at the findings for that specific application type, because the findings that I just showed you, those were based on for a zone change. But
Yeah,
that doesn't necessarily mean, those findings are not necessarily the same findings for tentative map, right? Tentative map actually has a whole lot more.
so I guess when they make that recommendation,
Mhm.
if they just make it based on, members of the public felt this, that's pretty much going to be ignored because it isn't in relation to the master plan. And I guess stating that, or is there a way each advisory board could get a hard copy of the master plan? I mean, I have the electronic one, but it took a long time to download it, but and then the third question I had is if you could go over a subdivision versus a parcel map. I know there's differences, but I can't remember what they are, and there's
Tentative parcel map versus tentative subdivision map. Tentative parcel map is when only 4 lots are created.
4 lots. Okay.
Tentative subdivision map is when 4 or more lots are created.
5 or
5 or more lots are created, I'm
Okay,
sorry. With a tentative parcel map, those get approved by the planning commission. They don't go to the Board of County Commissioners. When it's a subdivision map, those get approved by the county commission. So,
okay, thanks.
so. And if you want a copy, you can email Erin or the clerks, and we can get you a printed copy. Mhm. Yes, sir.
Yeah. Quick, so I understand the planning commission, if the planning commission is the final authority, the property owner could appeal to the Board of Commissioners.
Mhm.
Then you mentioned appeals from the Board of Commissioners. Who is that appealed to?
The courts.
Well, okay,
The
so,
district court.
so is that then, but that has to be done by the so he's basically filing a lawsuit?
Yeah, they have to file a lawsuit in conjunction with the challenge there.
So there's no automatic appeal above the Board of Commissioners. It's a put your money on the table and
Yeah.
pay the attorneys.
Yeah, absolutely.
One other question, and this came up in the last one, is if the applicant makes statements at the advisory board or the planning commission that are not actually factual and in relation, I mean, I'll bring up the stagecoach one. So they said they were lot matching. And that's kind of, I think, what a lot of people got hung up on. They made that statement at the advisory board meeting. Is that taken into account in any way? Because it wasn't in the application, it wasn't in anything.
Well, So that specific example may not be a great example because lot matching doesn't mean they have to be identical. So,
Well, they said it'd be an extension of what is currently there, where essentially lot
Right.
matching is what they said. And I
Right.
think that's what got hung up.
and
with a
and,
lot of
and I
people.
we would classify that as an accurate statement. So it's not an inaccurate statement. I guess is what I'm saying.
That they're
that those
the
they would be
extension of the existing. Okay, so
Correct.
again, it comes back to the interpretation then.
correct.
Okay,
Yeah.
thanks.
So that wouldn't necessarily apply, but I mean, if we found out that information was false, that they provided false information, blatantly false, yeah, then that does come into consideration. However, and there's a process for us dealing with that. But again, we don't just take their word for it. We require evidence. So we require reports and stuff that back up what they're saying, and then those are reviewed by our engineers and our staff, our professional staff, that that's their job to know that stuff. So they're checking it to make sure that what they're actually saying is actually correct. So there's quite a bit that goes into reviewing these applications. I mean, and this is just the public process that you see. If I had to draw out the process that happens internally prior to even getting to this, it would be a much bigger slide. So why does staff always seem to recommend approval? I already touched on this quite a bit. No, staff frequently says no. I probably say no more than I say yes. So when we're reviewing this stuff, and that's not to say that that's our goal. It's certainly not, but staff's job in this role in this whole review process is, does it meet the standards? Yes or no. If it meets the standards, we recommend approval. If it doesn't meet the standards, we recommend denial. So there's no subjectivity in that. I mean, as long as it's spelled out clear in county code, if they meet that, then we recommend approval. If they don't, then we recommend denial. And that's really it. Companies and developers will rarely file a formal application if they know staff is going into a hearing with a recommendation of denial. Our permit fees are not necessarily cheap. For a conditional use permit, it's $2,500. So if you know that staff's going to go in there and tell the board what an awful project it is, you're probably not going to pay that $2,500 and go through that process, right? Same with like a tentative subdivision map. You're probably not going to pay all the review fees that we talked about, and the application fee, if you know that staff is going to go in to a board meeting and say, look, it doesn't meet this standard, it doesn't meet this standard, it doesn't meet this standard. Occasionally you'll get somebody that's willing to roll the dice on it, but it's not a great idea. And as I already stated, by the time an item has reached the CAB, the Planning Commission, and the Board of County Commissioners, staff has reviewed the project several times to make sure that the project meets the findings and the development standards. I mean, it has been reviewed. Generally the senior planner knows that pretty much inside and out. So I want to talk about some of the other questions that we normally get in some of the development standards, because probably the top one that we get is water and water rights. They're regulated by rights are regulated by the Nevada Division of Water Resources, not Lyon County. And so they're based on water rights, specifically are based on water that is available in the hydrographic basin. There's different types of water rights. There's ground and surface. Water rights are property right, much like zoning is, right? So Lyon County can't just take somebody's water right and say, oh, that water right's not good enough. I mean, that's really up to the state to determine whether or not that water right is appropriate for that project. But Lyon County doesn't get a say in that. Even if Lyon County regulated water rights, which we don't, the county can't just take that away. So for again, we get a lot of questions. Well, where's the water going to come from? Well, if the developer is able to come up with that water right, and the state water engineer agrees with that water right and says that yes, that's there, the county doesn't get to say, well, there's not enough water for that project. on the water rights side. Now we could on the water utility side in areas where we have a utility that's a little bit different because we have these will serve letters that they have to get from the utility showing that we have the capacity to provide it. But that's something that provides a lot of frustration for folks, and I understand. However, you just need to understand that Lyon County, that's not something that the state gives us the ability to regulate based on that. Something that we do have in county code, and this is required by law, is that for every new lot that is created, water rights must be permanently dedicated or surrendered to either the Division of Water Resources or our utility department, depending. So the Division of Water Resources, they get surrendered to the Division of Water Resources if that water right, if they're going to drill a well, a domestic well. If they're going to be on city water or county water, then those water rights get relinquished to the utility department, whichever one is appropriate. So currently in Lyon County, for each new lot that's created, we require 2 acre-feet of water to be dedicated. So for instance, now that's on the larger lot sizes, the ones that'll be on wells. On the smaller ones, there's a formula that goes there depending on how much water they actually use in the water. And it's, they work that out with the utility. But on the larger lots, for example, let's just say you talked about a parcel map. So somebody's splitting let's say a 20 acre parcel into 4 5s, right? They would have to produce 8 acre-feet of water that have to get permanently dedicated to the state. And then that water right can't be sold. It can't go anywhere. That has to be there. And that's based on the amount of water that is typically pumped or what you're allocated for a well in the state of Nevada, a domestic well, domestic.
That's the primary, correct?
Yeah.
Primary water.
So generally, if it's going to be serviced by a well, it would be groundwater, but correct, yes.
If it can be serviced by a well, so it can be serviced by a utility.
What do you mean? No, they would have to work that out with the utility. It's not quite as cut and dry. Yeah, water law gets pretty complicated, and I don't want to get too far off into the weeds on that, but in general, we require water rights to be dedicated for each new lot that's created. So when a subdivision comes in, there's a formula. If it's smaller lots, there's a formula that takes place, and they they work that out with the utility and figure out how many acre-feet of water they're going to be dedicating. Surface water, you mean?
Yeah, I'm sorry. Good combinations. So for some areas, they don't have groundwater, but they have some certain things.
So
Always have to be ground.
So that's going to be. Let me answer the question, I guess. That'll be up to the state engineer as to how they allow that to happen. Probably, again, I'm not an expert in water rights or water law. It gets very complicated very quick, but the engineer would be the one that would approve that based on the specific circumstances, not Lyon County. So. Yeah. So it just depends on where it's at and what it's, if you've got, a 5 acre lot out here in the middle of Silver Springs and there's no surface water to it, we're probably not the state engineer's probably not gonna allow that to work, right? So, but again, that's up to them. If they decide that it is. Something else that I want to point out here with regards to water rights is that when you convert ag water over to water for houses for utility use, there's a conversion that happens there. So let's just say you had 2,000 acre-feet of ag water. The state engineer doesn't give you 2,000 feet of water that can be used for housing. They lessen that amount based on a number of different factors. But if you think about it like this, when you're watering a field, a certain amount of that seeps into the ground and a certain amount of it ends up back in the system. When you're just using it for showers and that type of stuff, that doesn't happen. So they do that calculation based on how much is now not going to go back into the system. So you might end up with only 1,200 acre feet of water, by converting 2,000, and that's getting pretty far off into the weeds, but I want to point that out. So projects must have adequate water and wastewater to serve the development. So talking about water, the utility side of it. So the developer is responsible for any water and wastewater line extensions. Lyon County doesn't pay for line extensions to somebody's property for the development of a subdivision or for a house or something. They are responsible for having to come up with that money to pay for it. We don't pay for that infrastructure. Septic tanks are only allowed if not within 400 feet of an existing sewer line. The minimum lot size if you're on a well is 1 acre. The state has required that anything under 1 acre that's on a well can't be on a septic. And the minimum lot size, if you're not on a well and served by community water, is a 1/2 acre. And that's to ensure that you have enough separation and that you're not going to be so dense that it contaminates the well water. So spelled out in NRS. So again, Lyon County doesn't really get to have the say in that. Actually, except for the within 400 feet of an existing sewer line, NRS actually says if it's adjacent to the lot, we are more strict than NRS on that, and that we require it, to be converted if it's within 400 feet. That doesn't mean that the day the sewer line comes within 400 feet of your house, you're going to have to switch. It means that the next time your septic fails, if your leach lines fail or your tank fails, we're going to require you, we're not going to permit you to put in a new septic system. You will have to convert over. There are situations where you could end up being forced to be converted, but that is again kind of regulated at the state level with NDEP. So if they come in and say, well, there's too many septics in an area, we're going to have you put in a septic or a sewer treatment facility, they could mandate that some of the septics that are in that area come off. It gets, again, it's a little more off into the weeds, but there's a lot of factors that go into that. So roads, again, developers are responsible for building all the roads within a subdivision. Lyon County has a road maintenance department. We don't have a road building department. And so we also require them to do off-site road improvements if it leads up to their development. So for instance, the one that's going in Stagecoach, there's 2 existing roads that are not on their property that they're going to have to upgrade before they can build anything. They have to bring those up to new county standards. So that's something that's really important. People think, well, you're approving all this development, it's going to cost all the county all this money to put in these roads. Well, not really. It's not going to cost us anything at all. It will cost us in maintenance later on down the road, but in theory, the houses that are on those roads would pay for the maintenance through the property taxes and through, sales tax and gas and all that stuff. So there's no direct cost to build those roads to the county. So somebody talked about storm drainage and development. So we have standards for storm drainage. They're largely based off of FEMA standards. Some of them are more strict than FEMA standards, but what we have based on the 2018 guidelines are that the amount of runoff created on site and leaving the property must be the same before and after the development. All right. So when you add roads and rooftops to an area, that creates some additional runoff, right? Because there's less surface area for the water to seep into the ground. So they have to put in detention basins to capture, I think, I want to say it's 150% of the 100-year storm when that happens. So they have to have provisions for that in a development. That be it a commercial development where they're just building one building or a subdivision, they have to build detention basins and make sure that they're not creating any additional runoff. Further, discharge across property lines. So you can't divert with the way that water works, you can't divert it necessarily. You can move it where it goes on your property, but the same amount of water that enters your property has to exit your property at the other side, I guess. Surface drainage from any development area shall not cross any property line except by way of natural water courses, major drainage facilities, approved drainage system with a public storm drainage easement or permanent surface drainage easement. So the same water that ran on to the property before it was developed has to run off of the property on the other side, just as it did prior to the development. And I believe, I want to say that's state law. Yeah, so you can't, and it has to be in the same location. So you can't say, well, you know, let's just say this piece of paper was your property and the water comes in here and flows out here. You can't then like change it and have it come in here and then flow out here, because you could be changing how your neighbor. Well, because you're running that onto your neighbor's property, right? So you can't change the historic flow. So it has to go into the same spot. Now let's just say that the water comes in here and goes out here, and traditionally it ran diagonally, right? You could run it down here and then down here to get there. And that's what you see a lot of these storm drainage improvements do, but you can't, but it has to, where it flowed before, it has to flow after.
I have a question on that. So, they have the water that entered their property before and exited their property before. It's just passing through their property. They don't deal with that because it was there before. And then they have the water they're creating that can't go off their property. Can they mix the drainage devices with those two? I mean, how are you going to know if it's their property or not? Okay, so they have to have individual drainage devices that aren't connected to the flow through ones then.
Yeah, so there's a drainage study that has to be done with each development.
I just didn't know if they could mix those drainage facilities with each other, but they can't. Okay.
No,
thanks.
because you would be potentially be adding water that wouldn't be flowing off.
And you wouldn't know
And you wouldn't
whose
know,
water
right?
is whose, if
Yeah,
it's passed through or yours. Yeah.
exactly. I mean,
Okay,
I
thanks.
guess you could in theory figure out a way to do that by measuring it, but nobody does that. So. Yeah, yes, sir.
So when you're determining the capacity of a detention basin, are soil conditions considered,
Yeah.
like clay versus sand?
Absolutely. Yeah. Yep, all that stuff is taken into consideration. Like I said, quite a bit of work goes into that before anything gets approved. And again, we don't just take their engineer's word for it. Ours take a look at it too. So and if they're proposing something that's not necessarily a standard practice, we'll take a look at that, but we might charge additional fees to hire somebody that's an expert in that field to review that. So to make sure that we're having an independent third party take a look at that. So yeah. That kind of concludes my presentation. That concludes my presentation. I'm happy to answer any questions that anyone has. I'm sure this is a very brief overview of planning and how development works. It's obviously it's a lot more complicated than this, but just kind of a summarized version. So
Yeah, just a quick clarification. But first, I wanted to thank Steve, Erin, and yourself, Andrew. This has been immensely helpful. So thank you for the time. And since I'm old and stupid, I need to go back to the earlier question. So I understand an appeal from the county commissioners, you get out your checkbook, you have to hire an attorney, et cetera.
Mhm.
But when you're going from planning commission to board of county commissioners appeal, is that a right in state or county law? Or do I also have to hire an attorney?
as the developer, or
Yeah, so if I'm a property owner and I don't like the planning commission and their ruling for denial, if I want to go to appeal that, is that free? Is that a part of
Yeah.
state law? Is that state or county law that
I
enables
think
that?
both. I think NRS 278 would.
278, thank you.
Yeah, that's you only have 10 days, so you have to file, they would have to file that within 10 days. Yes.
I wanted to also thank everybody for coming. This has been really helpful. I think for your guys' sake, it would be really helpful if you could do some kind of presentation like this at the advisory boards, if we could get the members of the community to attend, because I think a lot of it is not really knowing the reality.
Yeah, I mean, we get a lot of folks that are frustrated about development specifically, but as I've stated, state law is very development friendly. That comes from a time when Nevada didn't have much of a population and they wanted to see growth. And so it's stayed that way until state law changes. And I don't even know that it really could change a whole lot just because of federal law as well, and the Constitution and property rights and takings and all that stuff. But you know, I mean, people get upset with the Board of County Commissioners or the Planning Commission or even the cabs about that and or staff. And really, there's not a lot that we can do if they're meeting those standards. Now, I told you I'd give you an example of something that was really helpful. It was actually at the Stagecoach Advisory Board meeting. We had somebody that was coming in for a parcel map. They were splitting one parcel into 4. And actually, I think it was our chair back there that Mr. Shirley that said, hey, this project is, you know, they've got major code enforcement violations on it. And so I said, okay, we didn't know that. The aerials that we had were old. And so we didn't know that there was an issue there. Sent my guy out there to go take a look at it the next day. Sure enough, there was code enforcement violations. We didn't want to encourage, or we didn't want to create a situation where we're turning one code enforcement violation into 4, right, by creating 4 lots. So we put a condition on that map that says that they have to clean it up before it could record. Generally, we try and address those types of situations with a condition rather than just a flat out no. So for instance, if for whatever reason we think that they don't meet the traffic standard, we would put a condition on that map that they have to meet that traffic standard. It's generally already on there. We have a standard set of conditions that we put on it, but that's something that we do to try to make sure that to make sure that they're meeting those standards, rather than just giving them a flat out denial, a flat out no. Yeah, Mr. P. Norman?
Yes. You just brought up traffic standards. There's been occasions where we've seen subdivisions coming through an approval process, a tentative map approval process, to where they don't have direct access onto the highway, but their access would be adding to an already overused access onto the highway, where NDOT has classified it as a class F, that it's already overused, but yet the staff report still says that it meets traffic standards.
Sure.
And so would that be a reason for a CAB or planning commission to deny or recommend denial?
Well, so I'm glad you brought that up. I remember specifically which application you were talking about. So NDOT actually, so there's one movement, one basically turn lane that was at an F rating on that particular intersection. However, NDOT's standard is that you have to have 2 or more at a failing rate before you can require them to do that improvement. So in that situation, they actually did meet the standards based on what the law is. We have to go by what the law says, not what we necessarily would want it to say.
So even though the failing site was from the side that they were going to be adding to.
Yeah, but again, see, that wasn't the county that said, yes, it meets it, or no, it doesn't. That was NDOT. If NDOT had come to us and said, no, we don't think that this is going to work, then we would have, either denied the application or recommended denial for the application, or we would have put a requirement in there that they upgrade that intersection. But because that is what NDOT's current standard is, that we had to recommend approval on that. They do develop, so I'll give you an example though of where the board could potentially turn something down based on traffic, all right? So they do a study and the study shows that it's not gonna, it doesn't, that the project adds too many trips per day and it would push it over that rating. That's something where the board could say no. Generally staff's going to catch that and they're going to say they're going to recommend denial anyway. But if somebody wanted to push that, or maybe there was a condition that the board, that staff that wasn't aware of, didn't know about, or missed, that the board might have input on. So for instance, let's just say that the staff report the traffic report didn't take into account some other future development that was already there, or let's just say that was already proposed further down that road, right? So their traffic report left that part out. The board could say, well, we approved something 6 months ago down there. This staff report or this traffic report doesn't take that into consideration. So that could be a situation where the board might use that as a reason to deny a project. Generally, most of those reports would take that into account, and that's generally something that staff does look for. However, sometimes something gets missed or something, or by asking the question, we might come back and say, well, yeah, that was approved. However, their time frame for actually completing that project has passed, so that project is expired, and so that's why it wasn't required. So again, there's quite a bit that goes into these applications, but there are things, that's why there's those checks and balances, so that you get a lot of eyes on it, and maybe there's conditions that we're just not aware of. It does happen. The Stagecoach one was a good example. Yeah, so that's why it's really good to go through this public process. So yes, sir.
Okay, so question. So let's say that development behind my house.
Mm-hmm.
So let's say, so let's say my house is right.
Uh-huh.
Not this owner, but previous owner decided he wanted to buy pancakes. He went out along this property. But a deed into the ground like this, creating a dip. Okay, water used to drain here.
Mm-hmm.
I have a gully that starts on my property on this side, which I could get this out to the road. But since they did this, now floods in my property next to my grill, straight into my house when we get around. So this guy could have been made to rectify that situation.
So that's a civil issue that you could certainly take him to court on. It's a civil issue that you could certainly.
Nothing the county or water resource or anybody.
If it was something that happened in the past, probably not. I don't know. I'd have to.
Yeah, we get those kind of questions a lot. The drainage guidelines they're not a county code. They're a guideline, and they apply mainly to development. And so there are a lot of cases where somebody right next door to you does something to their property that affects yours. Usually the county is not going to get involved in trying to solve that. There are exceptions to that, but that's kind of beyond the county's purview.
Yeah, generally that would be up to you to either work it out with the property owner or to file a lawsuit against them for damaging your property.
I don't know about you.
Does anyone else have any other questions? All right.
So we wanted, you have anything else?
No, I don't have anything.
Yeah, so we also just want to thank all of you for coming today. We appreciate the chance to present to you. We're open for questions, call, email, all that kind of stuff. And most importantly, want to thank you for volunteering. Lyon County has all great volunteers, and we really appreciate what you do to help your communities and help the county. Although you probably get pushback from us sometimes, we do appreciate your comments, input, and what you're doing to help the county become maintain a good place. So we appreciate what you do.
Thanks, everyone.